Greenie.
Good morning, sir. Before we begin the hearing today, there are two preliminary matters to raise. First of all, can we remind everyone that a restriction order is in place for this hearing? The effect of that order is that there is a 10-minute delay on the YouTube broadcast. And in relation to those present in this building, whether in this hearing room or in the remote viewing space, and in relation to those in the hearing room in Omagh, where there is no delay, there can be no publication of anything said in the course of the hearing until the delayed YouTube feed has been broadcast or the transcript published. The second preliminary observation is to note, sir, that this is the first hearing at the inquiry's new permanent home here at Bradford Court in Belfast. The space here has been organised to reflect the requirements of your inquiry, sir. Within this building, there is a dedicated space for bereaved families and survivors, as well as space for the press and an overflow remote viewing space for those who do not wish to be in the main hearing room. And importantly, there is a designated space for WAVE, who will be available should anyone wish to speak to them today or on any day that the inquiry sits. So that said, this procedural hearing today will deal with two broad topics. The first topic will involve the inquiry legal team providing an update to core participants and the public on the progress of the inquiry. So can we add that this is a topic upon which we consider submissions from the core participants will not be required once we have finished our address. The second topic for today will involve consideration of applications for anonymity of witnesses that have been made on a sample basis by PSNI and HMG. Submissions on those applications will be needed from those core participants who have lodged written submissions. So the order we propose for those oral submissions on anonymity is as follows. First, we will make, when we reach that stage, submissions on the general principles, and we will introduce, although only very briefly, the individual applications that have been made by the police and by His Majesty's government. Second, once we've done that, we'll hear from those who make the applications. So that is to say, we will hear from PSNI, and then we'll hear from HMG. And so we expect that we'll hear from them on both the principles that you should apply in dealing with these applications, and that you should hear from them also on the applications to the extent that they can do so in open today. Thirdly, after that, we'll hear from the bereaved family and survivor core participants on those same topics. Fourth, we'll address the progress of the closed material restriction order process, in other words, the CMRO process. And again, it will be necessary for us to record publicly areas which the inquiry legal team consider need urgent attention by some of those engaged in the process, so as to enable the inquiry to maintain its momentum, which otherwise may be lost or affected. And then fifth and finally, in relation to the first topic, we will set out the position in relation to the inquiry's closed facilities. The access to and use of these facilities bears directly on the ability of the inquiry legal team to ensure any closed part of your investigation is moved forward in a timely and comprehensive manner. Everyone involved in this process knows that there will have to be closed hearings, and to prepare for those closed hearings, the inquiry needs closed facilities at which it can receive and review closed materials. And so that much seems to us to be, and has always been, beyond obvious for your inquiry. So the topics. Topic 1, Chapter 3, and the issue of scope. So So that were always going to be some teething difficulties given that we've moved into the new building. I'm told that when the YouTube feed was started today, the delay was not applied. It is now being applied, but we need to break for 10 minutes in order to catch up. So you have my apologies, sir, for that, but would you rise for that short period, please? Yes, right.
Mr. Greening.
Sir, thank you very much. As you'll recall, I was dealing with the first of the 5 topics upon which we're updating core participants and the public at large. The first of those topics is Chapter 3 and the scope issue. As all in this room and indeed beyond will know, this time last year you directed, sir, that the Chapter 3 oral evidence hearings would commence on the 9th of March 2026. The effect of that direction, had it been possible to maintain, would have been that both last week and this week the inquiry would have been hearing evidence about the bombing of Omagh with a view to establishing, so far as possible, how the attack was carried out and by whom. And those, of course, are the principal purposes of Chapter 3. As all in this room also know, at the end of last year, you, sir, directed that the date of the 9th of March be vacated. This was for a number of reasons, including the state of disclosure of material from the Republic of Ireland, to which we'll turn, and the judicial review to your Special Advocate's ruling, which was heard, as it happens, by Mr. Justice McAlinden last Monday to Thursday, and in respect of which judgment is understandably reserved. On the 6th of March of this year, core participants were informed of the new commencement date for Chapter 3, but today is the first public revelation of that date. So the oral evidence hearings for Chapter 3 will commence on the 21st of September 2026, with an anticipated duration of approximately 4 weeks. Before moving on to other Chapter 3 related matters, I should say something about both parts of that last sentence. As to the first part of that sentence, namely the choice of the 21st of September, that, at the risk of stating the obvious, is a date in 6 months' time. The inquiry legal team is acutely aware of how disappointing this will be for many people. We understand that reaction, sir, and moreover we sympathise with it, because we are disappointed too. However, we know that most, if not all, will understand the importance of your inquiry not being rushed and being as comprehensive as it can be in addressing the terms of reference. The reality, sir, is that you are under a statutory duty to conduct a full and fearless investigation and to discharge your terms of reference, and we know that to do so is your determination. Achieving that made a postponement of Chapter 3 unavoidable. As has already been communicated to core participants, the date of the 21st of September of this year has been selected to ensure that Chapter 3 achieves what it needs to achieve. As we've said, one of the reasons, but we stress not the only reason, for adjourning the 9th of March date was due to material originating from the Republic of Ireland not being available. The volume of that material must not be underestimated, nor should its potential bearing on Chapter 3 and the inquiry's wider work. Excuse me. As we will come to in the next part of this update, the volume of that material means that although disclosure to and by the inquiry will be on a rolling basis, it will not all have been disclosed to the inquiry until June of this year. Once disclosed to the inquiry, it must be reviewed for relevance by our team and redactions considered and checked, because that's our process. And furthermore, once that material from the Government of Ireland is in the hands of core participants, they of course need time to consider it, and that's their process. In those circumstances, we hope it will be obvious that a date earlier than September to start Chapter 3 is simply not feasible. Furthermore, the first 2 weeks in September has, as all know, been allocated to the resolution of the sample closed material restriction order applications. And so I'll say more about the CMRO process in the fourth part of this update. Such a resolution of the sample CMRO applications, needs to take place as soon as possible so as to permit the open-close divide to be established and work on the preparation for later chapters to be progressed. So it was in those circumstances that you have identified the 21st of September 2026 as the earliest possible start date, and we, for our part, entirely agree with your assessment. As for the second part of that sentence, the duration of Chapter 3, the inquiry will sit on 4 days each week from the 21st of September until the Chapter 3 evidence has been heard. The evidence for the Chapter 3 hearing, as I set out a short time ago, is 4 weeks. That estimate reflects that Chapter 3 is about understanding what has been established about the methodology of the bombing and the people responsible for the attack. Some of this understanding arises from the Breslin litigation, and as such, the inquiry can use those proceedings as a starting point for what has already been established. But it's just that, a starting point. During Chapter 3, it will be important for the inquiry legal team and core participants, we suggest, to maintain the focus on the objective for Chapter 3, rather than moving ahead or seeking to move ahead into issues which bear directly on whether the bombing could have been prevented. So that need for focus is for 2 reasons. First of all, because Chapter 3 will form the bedrock of what will follow. As has been pointed out on many occasions in the past, it's only by understanding who was responsible for the Omagh bombing and how they did it that it will be possible to identify which of the previous incidents referenced in the provisional list of issues were the responsibility of the same people or the same group or groups. In turn, it will only be then that focus, it will only be once that focus has been identified, that focus can shift to considering whether those people might have been detected, deterred, or disrupted before they attacked Omagh. The second reason to maintain the focus in the way that we've described is because disclosure for Chapter 4 will not have been completed by the time we reach September 2026 and start Chapter 3. As has previously been made clear, it will be in Chapter 4 that overt investigative techniques and material in relation to the previous incidents will be examined. As such, both the inquiry legal team and core participants will not be across all of the evidence which is relevant to the subsequent chapters when we start Chapter 3. And such circumstances are, in our estimation, only likely to lead to confusion, duplication, and a lack of clarity if that which should properly be confined to Chapter 4 is started upon in Chapter 3. So, at the risk of repetition, the purpose of and the focus of Chapter 3 will need to be kept well in mind during that phase, Chapter 3, of your investigation. For all of these reasons, as has been explained in the past, a huge volume of factual evidence relevant to the bombing itself will be reduced to summary form. Core participants will have the opportunity to comment on those summaries to ensure that relevant evidence has not been overlooked. We anticipate that the first of those summaries will be made available to core participants at the end of April. And the inquiry legal team is working to ensure that core participants have access to all evidence which is referenced in those first drafts. However, as the understanding of the material from the AGS develops, it may be necessary to revisit those summaries. There are two further matters that we should address in relation to Chapter 3 before coming to, as we promised we would, the scope issue. In relation to experts, core participant engagement with the reports of the experts, whose evidence bears upon Chapter 3, has been working well from the inquiry legal team's point of view. The team of forensic scientists, led by Professor Gallup, is in the process of finalising the first draft of their Chapter 3 report, with a view to that being shared with core participants for their comments. The cell site expert, Dr. Matthew Tart, has completed his Chapter 3 report, and relevant comments from core participants are in the process of being fed back to him by the inquiry legal team. And so we are content with progress in all of those respects. We have previously emphasised the need for the core evidence relating to Chapter 3 to be digested into what we've termed, and what has been termed in other processes, an electronic presentation of evidence, or an EPE. That presentation, once completed, will draw together many strands into a coherent whole. In relation to the EPE for Chapter 3, as core participants are aware, the inquiry has engaged the services of experts in this field to create a presentation which brings together all of the material from PSNI, from the Republic of Ireland, and from the Ministry of Defence, together with other material that the inquiry legal team has identified as being relevant, and in particular in that regard, evidence of cell site analysis. So all of those strands are in the process of being drawn together into a coherent whole. So core participants will have access to this presentation in advance of the Chapter 3 hearing. While its creation is still underway, and it will not be possible to finalise it until the review of all the AGS material has been completed, it's the intention of the inquiry legal team to bring a draft of part of that presentation to Omagh and to play it to the family core participants who wish to see it in advance of the 21st of September 2026. And the date for that viewing of the draft has yet to be set, but our estimation is that it's likely to be at some time in April, so well ahead of the September start date for Chapter 3. We turn finally in this first part of the update to the issue of scope. This issue, which I'll say a little more about in a moment, applies across the inquiry's chapters, but we mention it in connection with Chapter 3 because it arose as a potential issue during the preparation for that chapter. The scope issue, as we've described it, simply put, is whether or not it is within the inquiry's terms of reference for you, sir, to investigate anything which touches upon the issue of the evacuation of members of the public in Omagh in response to the so-called warning calls on the 15th of August 1998. It will not be possible within a short time today to do justice to the nuance and complexity of the matters which have been raised. The starting point is that the latest version of the provisional list of issues, which of course is on the inquiry's website, sets out the approach of the inquiry legal team to this issue. However, may we say constructively and responsibly, the Foxlaw group of core participants have made observations around that approach I've just described. In turn, that has led to all core participants having the opportunity to consider and reflect on the approach of the inquiry legal team and the matters raised by Foxlaw in relation to scope. The inquiry legal team's position was, and moreover is, that to the extent it needs to be resolved, the scope issue resolution should occur by reference to the evidence, rather than on a theoretical or hypothetical basis. As such, the inquiry legal team's position was and remains that no ruling was required from you on scope at this stage. However, there was a suggestion within some subsequent responses from core participants that the matter needed ventilation and resolution sooner rather than later. In light of that, item 2 of the original agenda for this hearing today had been submissions on this point, namely whether or not directions needed to be given to drive towards an early hearing resolving this issue were required. However, and for this we are for our part extremely grateful for the communication which has taken place between Foxlaw and PSNI, all are now agreed, as we understand it, that submissions at this stage on scope ahead of Chapter 3 are not required. And on that basis, directions are not required. So, as a result, this issue of scope, to the extent that it needs to be raised again, will await the evidential circumstances in which it may arise in relation to any other subsequent chapter of the inquiry's oral evidence hearings. And so this isn't about pushing an issue down the road, it is about identifying the right point in time to resolve the issue if resolution is required. But can we make plain, before we move to issue 2, and make plain so there's no misunderstanding, that none of the individual officers who were responsible for the evacuation on the 15th of August 1998 will be called during Chapter 3. To the extent necessary, their evidence will be summarised during that chapter. So the second item upon which we are today providing an update relates to the AGS material and the Government of Ireland. We've touched already on some of what we're about to say, but this is an important area of work for the inquiry in which we recognise there is much public interest. A fuller picture than already provided requires to be set out for those reasons. 2 key events provide the context for the update today. The first of those is the signing of the Memorandum of Understanding between the inquiry and the Irish Government. That occurred on the 15th of April 2025, and the Memorandum of Understanding itself was published on the inquiry website the same day. The Memorandum of Understanding provides the framework within which the Government of Ireland will disclose material to the inquiry, which of course is the start of the process by which ultimately disclosure is made to the core participants. The second key event was the decision that you, sir, took to vacate the hearing on the 9th of March, due, but only in part, as we've already said, to the fact that you concluded that the material expected from the AGS would not be disclosed to the inquiry, processed and or provided to core participants in time for that start date. As all core participants now know, the inquiry has now received a very significant quantity of AGS material from the Government of Ireland. This material was prioritised at the inquiry's request by reference to schedules which had been provided by the Government of Ireland. In excess of 20,000 pages have been disclosed to the inquiry already by the Government of Ireland, and some of that material has already been processed by the inquiry and was disclosed to core participants last week. The mechanics of this disclosure exercise have been the subject of extensive discussion with the Government of Ireland in a series of face-to-face meetings. While we're at an early stage of this disclosure process, the inquiry legal team has been struck by the constructive and positive sentiments which have been expressed in those meetings, which sentiments have now received very substantial support from the product the inquiry has already received from the Government of Ireland and receives on a continuing basis. Inevitably, there are matters which require ironing out as issues arise, such as access to sensitive material under paragraph 25 of the Memorandum of Understanding, and we are still a long way off being able to say that all issues have been dealt with. But it is important that we say that the experience of the inquiry legal team to date is that those that we are dealing with in the AGS are responsive to our communications and have kept the necessary deadlines required for the efficient processing of this material from relevance through to the application of redactions. All of this is to say that although the substantial progress we're seeing has only recently begun, and although there is still undoubtedly a long way to go, with the completion of disclosure of AGS material to the inquiry relating to the Omagh bombing expected to conclude in June, it is appropriate, in our view, that we acknowledge the considerable efforts that have been made and the effective progress that is currently being made. And the inquiry legal team, we should say publicly, is grateful for those efforts by the Government of Ireland and moreover is grateful for that progress. But we don't underestimate the size of the request that we've made of the AGS, nor indeed the challenging issues which may need to be navigated. One such challenging issue is the resolution of disclosure of sensitive third-party equity material. So that is to say, either material held by the AGS, which contains sensitive information which originates from the PSNI, or material held by the PSNI, which contains sensitive information which originates from the AGS. In neither case would it be appropriate for this material to be simply handed over to the inquiry without proper handling protocols being put in place and with the respective third party being aware of what was happening. So we hope that makes sense. We recognise and have experienced that the AGS will be in possession of material that contains PSNI equities and vice versa. And it is not, we have acknowledged, appropriate for that material simply to be handed over without more ado. In relation to this issue of third-party disclosure, to which a solution needs to be found, at the inquiry legal team's request, the Government of Ireland and PSNI have provided the following joint statement, which they've agreed should be shared at this hearing. So, sir, this is very fresh indeed. And I quote from that joint statement. The PSNI and AGS have developed strong working relationships for the benefit of the Omagh inquiry. Legal representatives and officers have formed lines of direct communication to allow the relevant teams to meet and discuss pertinent matters that affect both organisations and their roles in serving the needs of the inquiry. We provide this short note so that all CPs can understand the joint practical steps being taken by both organisations to ensure that disclosure is progressed as swiftly as possible. Both organisations are committed to transparency and candour in all ways of working. We welcome this opportunity to share this information with CPs and their representatives. It was expected, continues the joint statement, and has materialised that both PSNI and AGS would hold a significant amount of material that was provided by the other. This includes both non-sensitive and sensitive material. Both organisations recognise that in the spirit of joint working relationships, there is an important need for each to liaise with the other in terms of material ownership and disclosure. This is not a new way of working and would also be the case in any other proceedings that involve the disclosure of material that was not owned by the disclosure provider. This is because the owning organisation will be best placed to understand and assess the impact of the disclosure into the wider public domain. Where sensitive material is concerned, this will require in-person meetings between the officers to view and discuss the material. The ability to share sensitive information digitally via sufficiently secure IT systems does not exist. PSNI and AGS can advise that examples of partnership working in respect of sensitive material have already occurred, such as the progression of the disclosure of the McVicker report in a manner that was agreeable to all information owners. At this stage, it's apparent, continues yet further the joint statement, that the greater volume of material that requires AGS PSNI cooperation is non-sensitive and is largely held by PSNI. In assessing its disclosure tranches, PSNI has identified, at the date of writing, in the region of 200 to 300 documents that originate from AGS within PSNI's disclosure material. Each of those documents range from a small number of pages to almost 100 pages in length. PSNI can advise that it took steps to manually prepare hard copies of almost 200 documents in February 2026 for physical transfer to the AGS. There are regular exchanges of such material, and AGS has similar and parallel processes for the review of PSNI material. The PSNI is grateful to the AGS for its cooperation in the collection of those materials for the purposes of AGS assessment. It may also assist to explain the practical steps required in the sharing of hard copy material. Upon receipt of the hard copy material, AGS has commenced a manual review of those documents and will be required to provide the PSNI with commentary on each individual item in terms of whether it may be disclosed with or without redaction. Where redaction is sought, these specific areas of redaction will need to be highlighted and explained. Those assessments then need to be provided to PSNI, and PSNI will need to manually input those assessments into the MP platform, that's Material Provider Platform, of relativity. Those steps will very evidently be resource and time intensive. This is not beneficial to PSNI, AGS, the inquiry, or CPs. For that reason, in January of 2026, PSNI asked the inquiry legal team to provide a facility whereby AGS can undertake an MP, again, material provider, review on relativity, relativity being our database. Discussions on this proposal have continued, continues the joint statement, through February 2026. AGS and PSNI look forward to working with the inquiry to achieve this joint aim of swifter review while making more efficient use of available IT. However, the protection of material has to be at the forefront of our minds while we attempt to achieve greater efficiencies. And the joint statement ends with these words: PSNI and AGS remain committed to developing this joint way of working and will continue to meet regularly to progress these important areas of disclosure. That concludes the joint statement of the AGS and PSNI. So we're grateful for this, and we will continue to keep under review how well this relationship is working by reference to the material which the inquiry receives from the AGS and from PSNI. It goes without saying that the disclosure of AGS material is far from the only contribution the inquiry is expecting from the Government of Ireland. There are two particular further areas which we acknowledge at this stage as matters which are in progress and in relation to which work continues. So two further matters relating to the work that we have underway with the Government of Ireland. The first of those two matters is disclosure of materials from parts of the Irish state outside of that material that the AGS is currently in the process of disclosing, which material is focused on the Omagh bombing investigation itself. The inquiry continues to raise and track its disclosure requests for this material, and we have already received some of this material which has been disclosed to core participants. So we are continuing to work with the Government of Ireland in relation to this area of its contribution to the work of the inquiry. The second of these further areas relates to witnesses from the Republic of Ireland giving evidence to your investigation. We don't propose, sir, to say very much about this, beyond acknowledging the current state of affairs. Late last year, a consultation was opened by the Government of Ireland with a proposed framework which amended an existing piece of Irish legislation, namely the International Cooperation Act 2019. On your behalf, the inquiry legal team did provide a response to the consultation we've just described. We don't intend to rehearse the content of that response for two reasons. Firstly, because it was circulated to all core participants in January, and so all who are most directly affected know and can understand your position in response to the proposals of the Government of Ireland. Second, because since then things have moved on. Last week, following the closure of the consultation period, the Irish Government published a bill entitled International Cooperation Omagh Bombing Inquiry Bill. That bill sets out the position of the Irish Government in relation to this issue. Their position is that the appropriate way for certain categories of witness, namely former ministerial office holders, current or former Irish state officials, and current or former members of the AGS, to give evidence to the inquiry is through that statutory framework. So that is their position. So we can well understand, indeed we know, that the mechanism for evidence to be given to the inquiry in that bill does not accord with the expectation or wishes of at least some core participants. Nevertheless, having made our submissions to the Government of Ireland, following a period of negotiation in which the inquiry's primary position was clearly laid out to the Government of Ireland, we do not consider this hearing to be an appropriate occasion for core participants to express their views about it. Sir, the inquiry has put much work into this issue, as we're certain all core participants know, and currently we are, if we can put it this way, we are where we are. Topic 3 for today's update is, as we indicated, the topic of disclosure and requests for witness statements that have been made by the inquiry legal team. So we'll begin with some headline figures before providing a little more detail and then concluding with an area of particular focus for the inquiry legal team. The headline figures are these. The inquiry holds approaching 450,000 pages of open disclosure, so not far short of 500,000 pages. All disclosure to the inquiry has to go through a process before it can be disclosed on to core participants. That is absolutely vital. Many will be familiar with what that process is, but it's important that we provide a reminder so that the scale of the undertaking and progress against it by the inquiry legal team can be judged fairly. All open documents received by the inquiry need to be assessed for relevance to the terms of reference of your investigation, sir. And they need to be checked for duplication. And can I say it isn't at all unusual for the inquiry to receive a number of copies of the same document, and it helps no one for us to send out to the core participants many copies of a single document. Furthermore, any handwriting needs to be deciphered. The documents need to be considered for redactions mandated by data protection and privacy laws. Your ruling, made earlier in this process, sir, in relation to suspects, needs to be applied. The issue of operational sensitivity, which again has been the subject of a ruling by you, sir, needs to be judged, and if required, as sometimes it is, 2 versions of the document or parts of it need to be created. One for the open database and one for the operationally sensitive database, both of which, of course, our core participants have access to. After all of that has occurred, a dialogue with strict timescales needs to be had with the relevant material provider and, if necessary, any third party with an interest. At the conclusion of the process, relevant and appropriately redacted documents are disclosed to core participants. And so anyone that wasn't aware of what the process was will understand that it is complex and time-consuming. As matters stand, 18 tranches of disclosure to core participants comprising in excess of 100,000 pages of documents have been disclosed by the inquiry. The process often works well, indeed very well. HMG, His Majesty's Government, and as we've said, the AGS are examples of that. In short, sir, what we have to undertake is vast. Notwithstanding, very considerable progress has been made. Of course, that progress is not and cannot be progress for its own sake. Rather, it is progress towards the oral evidence hearings, the first of which will be Chapter 3. It's of the highest degree of importance that this work, which involves very substantial input from all the inquiry's material providers, is efficient and constructive. And may we repeat that. It's of the highest degree of importance that this work, the work of disclosure and the process which is undertaken, which involves very substantial input from all the inquiry's material providers, is efficient and constructive. Because if it is not, it will place the Chapter 3 hearing under threat, and it will interfere, sir, with your intention to commence the Chapter 4 oral evidence hearings in early 2027. And we'll return to the importance of that disclosure work being efficient and constructive when we deal with our final point on this topic of disclosure. Before we do so, there is a little more detail to provide. Much of this detail has already been provided to core participants, but it's important, in our view, that the wider public is aware of it too. Based on the disclosure the inquiry has received to date, requests for witness statements under Rule 9 of the Inquiry Rules of 2006 have been made. A number of key individuals in the narrative events before and after the Omagh bombing have been approached, and these include, and so we certainly emphasise that word include, John Ware, an award-winning journalist whose 2 panorama documentaries, the first in 2000 and the 2008, can now be seen, with the benefit of hindsight, as important points in the journey towards this inquiry. Martin Bridger, who worked as a lead investigator for Pony in the period after the Omagh bombing, and who interviewed both Sergeant John White of the AGS and a man going by the name Kevin Fulton, who was an informant who had access to significant figures within the IRA. It was Mr. Bridger who was involved with Pony at key moments in the processes subsequent to Omagh, and who was later, of course, the author of what is known as the Bridger Report. Each of the significant figures in the Omagh bombing narrative, sir, has informed the inquiry legal team of their willingness to contribute to the work of the inquiry. In addition to those individuals, the inquiry continues to engage with Detective Chief Superintendent Baxter, Norman Baxter, who became the senior investigating officer of the Omagh bombing investigation in May 2002, and we also continued to engage with his deputy. PSNI has also been the subject of a number of statement requests, including one relating to the use of what is known as HOME, so that is to say the Home Office Large and Major Inquiry System, the electronic system by which large and major inquiries were to be conducted by 1996, and a corporate statement setting out the structures which were contained within and surrounded CID at the time with which we're concerned has also been sought from PSNI. A number of statement requests addressed to individual officers have also been sent, with responses to some of those in the hands of the inquiry legal team and in the process of being disclosed. Furthermore, a significant statement recently disclosed to core participants, which was prepared by PSNI, identifies those suspected of participation in the Omagh bombing and some of the evidential basis for that suspicion. At the risk of repetition, this will form a key element of what we have termed Part 10 of Chapter 3, the purpose of which is to draw together the evidence identifying those who are responsible for the Omagh bombing. The inquiry legal team will continue to be relentless in its efforts to identify witnesses who have relevant evidence to give. So we conclude the update in relation to open disclosure and requests for statements by returning to the issue of efficient and constructive relationships. So we do so acknowledging that all material providers are working hard in difficult circumstances to comply with substantial and sometimes frequent requests. And in saying what we do next, we don't in any way seek to suggest that there are not a very large number of people across a number of organisations who are doing their best to ensure that this inquiry, your inquiry, sir, makes the progress that it must. However, all timetables set for any of the inquiry processes, whether disclosure or statement requests, are imposed with a view to being achievable, while simultaneously ensuring that momentum is maintained, as surely it must be maintained. It's imperative that everyone involved in this inquiry is working tirelessly towards ensuring it is conducted in both a comprehensive and in a timely way. With all of this in mind, so we take this opportunity today to publicly record that it's the view of the inquiry legal team that as the pressure increases, it will be vitally important that all material providers are properly resourced to meet the dual requirements for this inquiry of being comprehensive and timely. When deadlines are set by the inquiry, they must be adhered to. If, for good reason, they cannot be adhered to, applications for extensions must be sought as soon as that state of affairs is identified. The inquiry legal team simply cannot work effectively if material providers are having to be chased long after deadlines have been missed. And so, to use a phrase we used earlier, that seems to us to be beyond obvious. So we judge that this is not the occasion for descending into further material. We have raised that material with those who we consider require an adjustment to their approach and, if necessary, an uplift in resourcing. As matters stand, we consider that there is still time for a course correction. And we say to those to whom we've been speaking, this is your chance. However, we do have sufficient concern about the risk of a loss of momentum that, if necessary, sir, we will bring this matter back at a procedural hearing in May with a view to a more detailed analysis being conducted. But our hope is that that will not be necessary. So I'm going to check, because we do, of course, need to have breaks from time to time for the benefit of those who are making a record of what I am saying. I do not think I will conclude my remarks within a period of time that will mean that we don't need to have a break. So now would be a convenient moment for a break. And I can see nods, sir. So would you rise for 15 minutes, please? And we're now turning to the fourth of our 5 topics, the closed material restriction order process. As the terms of reference recognise, and as representatives of core participants have on a number of occasions realistically acknowledged, it is inevitable that some of the material which it is necessary to investigate for USER to discharge the terms of reference will be, as it's termed, closed. And by closed, we mean it is material that cannot, due to justified national security sensitivity, be disclosed or explored outside of a narrowly defined group of people. Under the Inquiries Act 2005, which takes as its starting point that all evidence in a statutory inquiry should be publicly heard, withholding material from core participants and the public requires that a legal test under Section 19 of that Act be satisfied. That test requires USER to understand and ultimately rule upon the risk of harm or damage that wider disclosure of that material may give rise to. The risk of stating the obvious, the navigation of these issues is far from straightforward. The motivation behind genuine and justified claims that material should be closed is the protection of national security. So, in other words, preventing those hostile actors who would wish us harm from learning of things that they would then use to advance that aim. Conversely, for those excluded from access, and here we are thinking particularly, of course, of bereaved families and survivors, not being permitted access to evidence which bears directly upon the answers they seek will, to put it mildly, never be a comfortable or satisfactory position. And can we say we entirely understand that? The duty imposed by the Inquiries Act 2005 requires you, with the support of us, your legal team, to test robustly claims which are said to give rise to a legitimate exception, to the open justice principle. In January of this year, the inquiry legal team published 3 documents which together set out a comprehensive framework for the management of provisionally closed material. All of these documents, the documents we have published, are available on the inquiry website. Provisionally closed material is material which has been disclosed to the inquiry on its closed IT systems and which requires to be the subject of a restriction order under Section 19 of the Act of 2005 if it is to be withheld from other core participants. The comprehensive framework which the inquiry legal team set out in the CMRO notes early this year is the scheme by which these restriction orders are to be determined. That scheme takes the same approach as was taken in the operationally sensitive restriction order process, namely by testing the principles against sample documents falling into particular categories. This sample and category approach has a very substantial benefit. It permits for a ruling from USER against a manageable and defined group of documents across a range of potentially sensitive issues. That ruling, once given, will then provide the basis for the management of the remainder of the provisionally closed material, removing the need for what could be potentially thousands of individual restriction order applications, line by line, against paragraphs or pages or whole documents which are currently within the provisionally closed material. So such a process, if we were required to undertake it, would take years to complete and would be wholly unnecessary. Of course, as the CMRO process itself acknowledges, where documents do not fall into categories established by the ruling, then a further ruling, following the same approach, will be required. But the steps identified in the inquiry legal team notes are intended to avoid the need for that as far as is possible. They are also intended to simplify the position in relation to material providers who have disclosed only a very limited amount of provisionally closed material. In the case of these material providers, the challenge is to establish whether those material providers are asserting that the documents cannot be more widely disclosed, or whether, in fact, the sensitive material belongs to a different organisation. And again, the CMRO process accommodates that situation. Having set out the overarching structure, we don't propose to rehearse all of the steps set out in the inquiry legal team CMRO notes, but they can be summarised in this way. They are designed and intended to create a situation in which a suitable cohort of sample documents and categories are identified, that the categories are shared with those who are not cited on the closed material content, with a view to maximising the opportunity for meaningful contribution by them, and that, in the course of the first 2 weeks of September this year, as we've mentioned already, the applications will be heard. So the first week, a week in open, so that the family and survivor core participants can make their submissions along with the media, and then subsequently the need, as is inevitable, for a closed hearing. Before we leave the subject of the CMRO process, it's appropriate for us to say something further about the need for efficient and constructive engagement from material providers on the closed side. What we have to say is identical in sentiment to what we said about open disclosure and witness statements just before we took our 15-minute break. It is of a high degree of importance that the CMRO process is resolved in accordance with the timetable that has been set. That necessitates all material providers working digitally, about which we'll say something more in a moment, and in a way that is transparent with the inquiry legal team. This requires all material to be scanned in an appropriately secure way and transferred to the inquiry legal team on the secure IT system that it's using. It must be catalogued and it must be properly indexed. And nothing must be allowed to fall between the cracks or to delay the inquiry's progress. As with the open disclosure and witness statements, it's not necessary or helpful to descend into further detail at this stage. However, as with that topic, we publicly register our concern that in relation to some of those with whom we've been in correspondence about this issue, a course correction is required. It's well understood, sir, by your team that this is a challenging and technically difficult area. However, solutions must be found so that all relevant material responsive to the requests which have already been made, some such requests being well over a year old, is available to the inquiry. The CMRO process is a key stepping stone to breaking out into open what can be broken out and preparing what remains for the closed hearings. But it will be in the hearings that follow that process that the terms of reference will be answered. As we've said before, it is essential that those hearings are comprehensive and timely. The fifth and final matter of update before, sir, we'll invite you to break for lunch and hear submissions on anonymity after lunch. The fifth and final matter in relation to which we are providing an update today relates to the inquiry's closed facilities. Ordinarily, this would not be a subject which needed to be raised publicly. It's an issue that the core participants and the wider public would rightly expect should be resolved efficiently and behind the scenes. Furthermore, it's a subject about which, if it is to be raised, care needs to be taken given the sensitivities which surround sites which provide access to closed facilities. Despite all of this, the inquiry legal team thought it was important that this issue be ventilated at this stage because progress has not been as smooth or satisfactory as may have been assumed. And that in turn has had an impact on the inquiry legal team's ability to progress the close side of this inquiry. Before we go any further, we would wish to acknowledge and thank the Northern Ireland office for the position which has recently been secured in London and which we are anticipating will shortly be secured in Northern Ireland.
That's the Northern Ireland office acting as the sponsoring department for the inquiry.
Precisely that, sir, yes. As all core participants will understand, the volume of material which is relevant to this inquiry's terms of reference necessitates digital working. The idea that we might work from hard copies only needs to be stated out loud to realise that it would be ludicrous. And that digital working is a necessity is so despite the fact that in 1997 and 1998 the digital revolution was, to say the least, not at the stage it has now reached. Digital working on the closed side requires access to a highly secure network which ensures that national security sensitive material is securely held. And it will be a surprise to no one, bearing in mind the subject matter, sir, of your terms of reference, that the inquiry has arranged for and last year was given access to such a network. However, the use of that network requires that terminals, which are only available in accredited environments, can be accessed so that material which is on the network can be viewed, managed and developed in an appropriate way. This, we have to say, has not proved to be straightforward. We'll start with the position in Northern Ireland. At an early stage of the work of the inquiry, a location was identified which was intended to give access to the secured system. However, that facility still has not been completed. As such, those members of the inquiry legal team based in or working from Northern Ireland do not have unfettered access to the secure system while here, and arrangements have to be made to be hosted by other organisations. As may be obvious, that situation is not conducive to efficient working. The current position, as we understand it, is that the facility in Northern Ireland will be completed by the end of next month, so the end of April. But there will then be a further period of delay, about which we're currently uncertain as to the period, while the IT that we need is installed. That state of affairs is not satisfactory. The position in London has been better, but was still unsatisfactory. A shared arrangement was provided, but far too few terminals were there, and in circumstances, we were given access in circumstances in which there were permissions and sometimes constraints which were required for parts of the ordinary working week. We're pleased to report that a solution has been found for this in London, which is due to commence at the end of this month, March. It will provide exclusive access to the necessary IT system in an environment which is much better suited to the nature of the work of the inquiry. The arrangement, sir, in London was arrived at as a result of a meeting that you had with the Permanent Secretary to the Northern Ireland Office last month, following concerns being raised by you, sir, over a substantial period of time about the unsatisfactory nature of the arrangements then in place. The inquiry is grateful that a solution has now been found, particularly as the closed material restriction order process, as we've said already, gathers pace towards a resolution in September.
And perhaps it should be clearly understood, lest there should be any doubt about it, that although the Secretary of State for Northern Ireland is a core participant in these proceedings, my discussions and correspondence with the Permanent Secretary was in her capacity as head of the sponsoring department.
It's, again, precisely that. So we've nearly completed our updates. But before we leave the issue, this fifth issue that we've been dealing with, we should provide one further detail which we hope will provide reassurance. Recognising that this issue was developing last year, the inquiry has taken steps to ensure that whatever time has been lost by these unsatisfactory arrangements can be gained back. As a result, there will be a surge in the inquiry team resources on the closed side to put us back to where we should have been. That surge has started and will further increase once the new facility in London is available to us at the end of this month. So that is all we propose to say by way of update. We hope that it has been helpful and informative both for core participants and for the general public. And as we indicated at the very beginning of our observations, it doesn't seem to us that this part of the hearing will benefit from submissions or observations from the core participants. And assuming that that is so, this would be an appropriate time to take our lunch break for, so we suggest an hour or so, so until about 1:20, when we'll return and we will make some submissions about the applications for anonymity of witnesses that you have received from His Majesty's Government and the Police Service of Northern Ireland.
All right. Thank you, Mr. Greenie. Mr. Greenie.
So good afternoon. At about 1:45 midday today, we took a break from the proceedings and we returned to court at about midday itself. In between those two times, the inquiry legal team became aware of some concerning reporting which had started to appear on the internet. And the reporting was concerning because it was inaccurate and unfair to the government of Ireland. That there was an exchange, sir, between you and I about that, during the course of which you expressed some firm views of your own. Unfortunately, for reasons that I'm not fully aware of at the moment, that exchange between the two of us was not broadcast on YouTube, and it's therefore likely that the media is unaware of it. In any event, in the period since midday, we've become aware that the problem is more widespread and deeper than we had understood at that stage. So the upshot of what I've been told, and I've been told in the last couple of minutes a number of things by a number of people, is that what I said at about midday today about the inaccurate and unfair reporting was not broadcast either on YouTube and or to the press room downstairs. In any case, there is a realistic possibility that the press is unaware that there is inaccurate and unfair reporting out there. So what I'm going to do is just go back to the start, back to midday, explain what it was that has given rise to a concern, and then go on to explain why that concern has deepened over the course of the nearly 2 hours since then. So shortly before midday, we became aware of a news piece that had been published on the webpage of a prominent newspaper in Northern Ireland. And what that piece said, and I won't name the paper because there are reasons to believe that the error does not lie with them. But what the piece said was and I quote, "The next phase of hearings at the Omagh bombing inquiry will take place 6 months later than scheduled," the lead counsel to the inquiry has said. On Thursday, Paul Greeny, KC, said that they will now begin on September the 21st. He said, the report continues, the delay was due to material originating from the Republic of Ireland not being available. And so the report, I was going to say gave the impression, it didn't just give the impression, the report effectively stated that our position had been that the reason for the postponement, described as delay, of Chapter 3 was because the Republic of Ireland had not made material available, which would have been bad enough. Since then, we've become aware of other reports on other news websites. One of them, again, I won't give the name of the website because, again, there are grounds to believe that the fault may not rest with with them rather. But the second report that I'm looking at reads, quotes, "The next phase of hearings at the Omagh bombing inquiry will take place 6 months later than scheduled. The delay is being blamed on material from the south not being available." So the position is that I most certainly did not say during the course of my remarks this morning that there was only one reason why Chapter 3 was being postponed. Still less did I seek to attribute any blame to anyone, and certainly not to the Republic of Ireland. What I explained during the course of my submissions to you, sir, was that there were several reasons why it had proved necessary to postpone Chapter 3. So the way in which the reporting has come out is undoubtedly inaccurate. It is undoubtedly unfair to the government of Ireland, sir, and as you observed in the exchange between us that was not broadcast, that is particularly unfortunate given the sensitivity of issues relating to the government of Ireland and our relationship with them. I'm told that it is likely that the problem with the inaccuracy of the reporting emanates from a single source, namely the Press Association. And I've also been told in the last few seconds that the Press Association has corrected its piece in relation to this, so that it is to be hoped that there is no further inaccurate reporting of this type. But can we be clear, anyone who has based their reporting of the proceedings this morning on the basis that we suggested that the Government of Ireland was the sole cause of the need for the postponement, anyone who has reported on the basis of the PA report that the Government of Ireland was being blamed has made a serious error and must correct its copy.
Well, it's most disappointing, Mr. Greeny. The arrangements through which the Press Association report on proceedings in inquiries such as this are well known and are relied upon both by the tribunals and by fellow journalists, relied upon to the extent that trust is imposed upon the Press Association to accurately record what is being said in the proceedings and to provide accurate information to their journalistic colleagues. It is extremely unfortunate that hasn't turned out to be the case during the course of today's proceedings. And it really mustn't be allowed to repeat itself.
So we entirely agree.
Thank you.
So we'll turn then back to the purpose or purposes for which we're all here today. And as I indicated at the beginning of today, the second broad topic that we are going to be dealing with relates to applications that have been made by the Police Service of Northern Ireland and His Majesty's Government for anonymity for witnesses whose interests those organisations represent. And so, to be clear, by anonymity, we mean the withholding of the name of a witness from the public and from court participants, or, in certain cases, only from the public pursuant to a restriction order under Section 19 of the Act. The question of whether a witness should be granted special measures, so in particular screening, whether or not they have anonymity, is in our view a separate issue that we intend should be dealt with later once the identity of those witnesses who must give live evidence is known, because, as is obvious, a witness who is not called to give live evidence does not require a screen. So the order of these things, the sequence of these things needs to be to address anonymity first, and then separately and subsequently address the issue of any special measures that any witness, whether they have anonymity or not, seeks. The inquiry legal team, sir, as you know very well, published an anonymity protocol as long ago as the 11th of July of last year. More recently, on the 2nd of February of this year, the inquiry legal team published a note on the inquiry's process, or at any rate proposed process, for restriction orders for anonymity. Each of those documents is on the inquiry website, and so we see no value for you, or indeed for anyone, in us rehearsing the content of either or both of those documents. And that is for two particular reasons. First, as we understand it, no one takes issue with the procedure that we have submitted is the appropriate one of you, sir, ruling on a number of sample applications for anonymity, enabling the principles to be established and then applied to subsequent applications. And second, the note published on the 2nd of February addressed what we, the inquiry legal team, consider to be the relevant legal principles that ought to be applied to applications for anonymity in, sir, your inquiry. And that's so whether the relevant principle arises under the duty of fairness at common law and or under Section 17 of the Act of 2005, or under Article 2 or possibly Article 8 of the Convention. In the result, having studied the submissions of others, we, sir, don't detect much, if any, material difference between the views that we expressed in the note about principles and the views of others who have made submissions in writing. So going through the note, let alone going through the detail of the authorities, seems to us to have no value for you. So we do, though, consider it's important that we should say the following, which relates to the principles. One, open justice is a fundamental principle to which you must have regard in considering these applications. And we know that you will need no persuading of that as a proposition, given, sir, that you have made clear on a number of occasions that open justice will be at the forefront of your thinking in your rulings on any relevant issue. Two, however, where the Article 2 rights of an individual are engaged, it is at the very least highly unlikely that they will be trumped by the Article 10 rights of the press. 3, each application made now or in the future must, we accept and agree, be given separate consideration, but on the basis of the principles that are established by your ruling. And 4, the principles that bear upon the applications apply just as much in Northern Ireland as in any other part of the United Kingdom. So the legal framework is common across the United Kingdom. However, in relation to that 4th point, what you're being asked to do, as we understand it, sir, in particular by the submissions of PSNI, is to apply the principles in the context of Northern Ireland. So the submission made on behalf of PSNI is this, and we quote from their submissions: the law is the same, the factual context is different. So we know that Mr. Henry, on behalf of the police, will develop, to the extent that he considers appropriate, his arguments set out fully in writing on the issue of context. But it seemed to us that the opening words of the judgment of Lord Carswell, in the very well-known case of Ray Officer L, so which is at tab 23 of the authorities bundle, and the passage we're going to cite is at page 677, it seems to us that those opening words provide a useful starting point. And what Lord Carswell said was this, it's paragraph 3 of his opinion: "My lords, police officers in Northern Ireland have suffered great hardships over many years as the result of the civilian disturbances and their manifold consequences. Some 300 were murdered by paramilitaries and many others sustained serious injuries. Numbers of them had to move home, sometimes at very short notice because of an immediate threat of attack. They regularly kept secret, even from their neighbours and friends, the fact that they served in the police and concealed their occupation in documents wherever possible. They and their families lived under constant threat and could never feel free completely from fear." So it further seems to the inquiry legal team that C's application for judicial review, the judgment of the Court of Appeal in that case, which is at tab 44, also contains important passages on the issue of context and indeed on other issues. There are a number of passages that are relevant to context. Paragraph 43 at page 1226 of the authorities bundle may be thought particularly striking, in which the court said the following, quotes, "In the context of Northern Ireland, which has been subjected to decades of homicidal attacks on individuals by organised terrorists, the threat to life has been real, though for the bulk of the population is not a threat directed at them individually, so that for most the risk is not present and continuing in the sense of immediate to them." This was a case that was decided, I think, in 2012. "For some," the judgment continued, "such as members of the police force, the level of threat has been and continues to be at a much higher level, and it is much more immediate. It cannot be considered as anything close to fanciful, and it is significant." Furthermore, sir, our view is that the decision of Mr. Justice Humphreys, sitting as a coroner in the Coke inquest, that's tab 54, is also likely to be of assistance to you, sir, in determining these applications, bearing in mind that it too has much to say on the issue of Northern Ireland context and on what is described in some of the authorities as the precautionary approach that ought to be adopted to applications such as this. So that's all we propose to say about matters of principle so far as they bear upon these applications. As for the actual applications that have been made, they speak for themselves and will be spoken to by counsel representing PSNI and HMG. But all we'll say is this, as for the PSNI applications, by written submissions at tab 14 of the open bundle, PSNI makes an application for anonymity in respect of 5 former RUC and PSNI officers. In respect of each of them, there is a short gisted open witness statement and a closed witness statement, some of which have exhibits. The level of anonymity sought by 3 of the officers is anonymity in respect of both the public at large and core participants. The level of anonymity sought for the other 2 is anonymity from the public, but not from core participants. The damage assessment on which PSNI relies is the JTAC assessment, for which there is a gist, sir, at tab 24 of the open bundle. And JTAC, the Joint Terrorism Analysis Centre, is the body which has responsibility for making risk or damage assessments of that type. That damage assessment confirms that if the name of a former police officer were to be made available in the public domain, this will, to quote from the assessment, likely increase the dissident Republican intent and capability to target that individual. And so in the closed hearing tomorrow, you will be able to have regard to the full JTAC assessment, and consideration will need to be given to whether more can be broken out than has been broken out so far. There is concern that we've identified among the family groups, advanced in particular in the submissions of Mr. Southey, that the damage assessment is not adequately individual. And it's suggested that you, sir, will not have sufficient information to resolve the applications. And that is something which, it seems to us, it would be helpful for PSNI to address in its submissions today. Furthermore, both the submissions of Mr. Southey and Mr. Toll draw out the feature that we've just identified of 2 applicants not seeking anonymity from core participants. In its submissions today, PSNI should, it seems to us, explain to what extent it relies on the damage assessment or any other evidence to support its proposition that disclosure to core participants under terms of confidentiality would not be sufficient to protect the rights of all 5 former officers, not simply 2. As for the position of HMG, HMG makes a single application for anonymity for a single person who is to be the corporate witness for GCHQ and who holds a senior role in that organisation as a deputy director. That application is supported by open and closed witness evidence about the individual's personal circumstances and an open and closed damage assessment. And so we do recognise that in respect of that application, a lot of the detail can only be dealt with tomorrow in a closed setting. So that's all we propose to say, save to set out the order in which we invite submissions on the issue of anonymity, which is this. First, Mr. Henry, on behalf of PSNI. Second, Ms. Fee, on behalf of HMG. Third, Mr. Southey, on behalf of the families that he represents. Fourth, Mr. Toll, to the extent that he wishes to add anything on behalf of those that he represents. Following the family submissions, it seemed to us that it would be fair to permit counsel for PSNI and HMG to make any short responses strictly in reply, and then finally we may make some short submissions of our own, although we currently judge that to be unlikely. And so what I'm told is that it is not necessary for counsel to leave their seats in order to make their submissions, but can I indicate that the microphone for each advocate who is to speak should be switched on? And I'm sorry to ask, but could Mr. Henry first of all put his hand in the air or indicate his position so that those who operate the microphones can see where he is? So that's all we're supposed to say at this stage.
Thank you, Mr. Greenie. Mr. Henry.
Good afternoon, my Lord. I know that Mr. Greenie has helpfully indicated that there's no requirement for counsel to leave their seats, but just out of the force of habit, I wonder if I might be permitted the indulgence to stand whilst making my submissions.
Of course.
And your Lordship can hear me okay?
You're just a touch soft.
I'll bear that in mind, my Lord. Lord, as you've heard helpfully from Mr. Greenie already, there are 5 sample applications before you today on behalf of the PSNI. They all relate to former police officers, both with the RUC and the PSNI. You will have seen from the table summarising the applications that 2 of those former officers were special branch officers, and 3 of the 5 were CID officers. And as has also helpfully been indicated by Mr. Greenie, you have 2 sources of evidence from each of them, which contains individual particulars about their applications or in support of their applications. The first is the open statement. The second is the closed statement. There are then 2 categories of general evidence, if I may describe it in those terms, in broad support of all of those applications. And they are, first of all, the JTAC assessment, which Mr. Greenie has already made reference to, and further, the bundle of open source materials which was supplied along with those applications by the PSNI. So I'll come to that evidence in due course, Lord. But one of the opening observations that we would make at this stage and repeat from our written submissions is that whilst the bulk of the task which the inquiry has in front of it is a retrospective examination of events which have already taken place, this exercise is different. It's a predictive exercise. Predictive in difficult circumstances. That poses challenges for the decision maker, my Lord, and arising out of those challenges in a Northern Ireland context, in particular, we have arrived at the precautionary principle, which is something which myself and no doubt Ms. Fee will address you on in due course as well. But just to assist your Lordship from the outset, my submissions will cover the following main topics. Firstly, Article 2 and the test over which there doesn't appear to be any controversy. Secondly, the evidence that we rely on in support of the applications. Thirdly, I'm going to touch a little further on the issue of Northern Ireland context for making this kind of application and its impact on this kind of application. I'll then turn to the common law test, and then finally touch briefly upon some of the submissions which have been contained within or set out in the Fox Law submissions. So, Lord, in relation to the first of those issues, Article 2, everyone has agreed that we're dealing with the operational duty or a limb of the operational duty arising from the significant case of Osmond v. the UK. And if Article 2 is engaged insofar as that operational duty sets out, then the duty which arises for the decision maker is to take reasonable steps. Those reasonable steps are judged in the circumstances of the application. And that's again something which I'll come to in due course. But the first question for this inquiry to decide is Article 2 engaged? Relatively straightforward test now, following on from the decision of Re Officer L. The inquiry will have to decide whether there is a real and immediate risk. A real risk in these circumstances is one which is more than trivial or fanciful, and has been observed in the inquiry legal team note on legal principles already. That's a relatively modest threshold. The second component of that first part of the test is whether the risk is immediate. And by immediate, what is meant is whether the risk is present and continuing. Secondly, then, in the context of an anonymity application about giving evidence to the inquiry has to decide whether the giving of that evidence either creates or materially increases the risk. Again, an uncontroversial statement of principle arising out of the Officer L case. And thirdly, and finally, insofar as the general principles are concerned for whether the test is, for whether Article 2 is engaged, is the nature of the risk. And the nature of the risk must be loss of life or death. Now, with that in mind, my Lord, I was going to, just before turning to the evidence, I was going to quote from paragraph 3 of the Officer L decision. There's no need to do that. Mr. Greenie has helpfully read that out aloud to you and to those present. So with that in mind, I'm going to move on to touching upon the evidence, Lord, and I'm going to begin with the hearing bundle, and then after that I'll move to the open source bundle. So beginning with the hearing bundle, I'm going to ask that the court turns up page 158, please. And whilst your Lordship is turning that up, what I'm inviting you to consider here is the open statement from the first of the 5 officers who are making applications. This is officer number 1. And I would respectfully invite your Lordship's attention to paragraphs 4 and 5 to begin with, please, on page 158. You'll see, my Lord, that under the subtitle threats, both general and specific, beginning at paragraph 4, the threats and risks to my life I experienced in the early part of my police service had a very serious and demoralising effect on myself and my staff, which consisted of a very small team. And we know that this Officer 1 was one of the 2 special branch officers making an application. In paragraph 5, he continues, a direct and serious threat to my life arose later in my career from North Armagh Provisional IRA and resulted in significant protection measures having to be taken, which remain to this day. And just pausing there for a moment, Lord, you have 5 different officers with 5 different statements setting out 5 different sets of individual circumstances. Respectfully, I'm not going to take the inquiry through all 5 of those today, but they do set out a consistent theme of the officers having experienced personal difficulties with their security as a result of their service as a police officer. So this officer has described the threats and difficulties that he faced at paragraphs 4 and 5. At 6 and 7, he moves on to talk about the type of effect that had on him. In paragraph 6, he says, as a consequence of my sensitive role, I've always kept a low profile, avoiding publicity and staying below the radar. I have practically no social life outside close friends, and this has had a huge impact and detrimental effect on my family, which they remind me of to this day. Touching, my Lord, on the personal impact and something which will be more relevant to the subjective fears that we'll discuss in due course whenever we come to talk about the common law test. Below paragraph 6, the officer sets out the observations about the attempted murder of Detective Chief Inspector Caldwell and also the targeting of some retired officers by Damien Duffy and Shay Reynolds, for which they were convicted in July 2025. Further, paragraph 7, this officer describes, I have maintained a high security blanket since my retirement, as I wish to avoid publicly confirming my former role, my identity, and that I remain part of the community in Northern Ireland. This has become the norm in my lifestyle. I wish to live without having the fear of my identity being made public to the extent it will lead to the resumption of terrorist targeting. And then after that, Lord goes on to talk about the stress that this has placed on him and his family. So that gives us the court, or the inquiry, some insight, a snapshot into the into what the individual officer has experienced and the effect that it has had on him and his loved ones. I'm now respectfully going to ask that the inquiry switch to a different bundle and look at the open source materials. That's the bundle consisting of some 400 pages.
I think I've got these in two collections, Mr. Henry. Is that the same way that you have them?
In my collection, Lord, I have a single collection divided by tabs from 1 through to 45, page numbers beginning at 1 through to 415.
Yes.
And it's that bundle of 1 to 415 that I would like to focus on now.
Just bear with me a second. I've got bundle A running to pages 1 to 217 and bundle B running from pages 1 to 207. Bundle B commencing at tab 26.
It may be that, may I ask what the first page of bundle B is, please, my Lord? It may be that there's...
Well, it begins the numbering sequence again at page 1.
Well,
would it help if I used hard copy?
It may be if we have a hard copy. I have the same two bundles as the chairman, Mr. Henry. My first bundle runs from page 1 to page 217 and tab 1 to tab 25, and my bundle 2 runs from tab 26, page 218. So do you not have in your second bundle page numbering in the bottom right-hand corner?
I do, yes. So it begins at page 218.
Yes.
At tab 26, my Lord, on page 218.
Yeah.
Well, I'll...
So if we use those numbers, then I'll be able to follow on screen.
That's very helpful, my Lord, thank you. So, unfortunately, my Lord, I'm going to go backwards and forwards a little bit through this bundle in an attempt to take you through the entries in a chronological order, such as they arose at the time, rather than where they appear in the bundle. So with that in mind, I'm going to ask you to first turn up page number 345, please. Or I beg your pardon, just with the new adjustments, my Lord, I think that will be page number 343. Inquiry page, the inquiry number is page 345. And what your Lordship should be looking at is a news article from the BBC, begins on the previous page, 342, and the title states, Constable Carroll Murder.
Yes, I have that.
So, my Lord, if you look at the beginning of page 343, you'll see that it reads in this open source document, Constable Stephen Carroll was murdered in March 2009 during a surge in dissident Republican activity. Just 2 days before, the officer was shot dead. 2 soldiers on duty at Mazarine Barracks in Antrim, Northern Ireland, were killed by the real IRA. But it was the continuity IRA which claimed responsibility for the death of the police officer. So just pausing there for a moment, my Lord, we have 2 fatal shootings in close proximity to one another from 2 different dissident Republican groupings, both in 2009. And further on down that page, my Lord, you'll see 4 paragraphs from the bottom that the deceased Constable Carroll was a husband, father, and grandfather. And in the following paragraph, you'll see that he was starting to talk about retirement. So this was a constable who was in long service coming towards the end of his policing career. And over the page at the top of 344, you'll see the officer had only 1.5 years of service left. My Lord, just bear with me one moment to get you the correct page number. Page 312 and 313 next, please. What I'm going to talk to you about here in terms of this article is a young former police officer, Peter Heffron, who was seriously injured in 2010. So moving forward a year from the last incident. And hopefully what your Lordship should have on page 312 is the beginning of a BBC article which references the former officer's name and that he was injured. If I may take you then to the top of the next page, 313, it provides some details. A former PSNI officer injured by a dissident Republican bomb 14 years ago has said, knowing what he knows now, he would not have joined the police. It goes on to talk about him being in a wheelchair. The 4th paragraph down, you'll see his serious injuries. As described, his leg was amputated as a result of the bomb exploding underneath his car. And in the next paragraph below that, you'll see that it was in County Antrim in 2010. Just over the page then, Lord, at 314, you'll see some further details that Mr. Heffron was travelling in the car on his own. It was anticipated initially that he would travel with his wife on his way to work. He left his home, was travelling to work when the bomb exploded underneath his car, approximately half a mile from setting off. And he goes through later in this article to talk about the steps that he took on the day. And also, you'll see on the next page, 315, that he had previously been the subject of some threats which were the cause of a move to a different area of Northern Ireland in which to discharge his constable duties. So this is a young constable in 2010 who was the subject of an assassination attempt using a car bomb. I'm now going to ask, Lord, that you turn to page 359, please. And my Lord, what you should hopefully have in front of you is another BBC open source article, title of which refers to Ronan Care. And if I may ask then that you turn over the page to 360. The article begins, the PSNI said it believes that there are witnesses in the community who may hold the key to vital evidence. Then it goes on to talk about Constable Kerr himself. Constable Kerr, 25, died in a booby trap car bomb in Omagh, County Tyrone, on the 2nd of April 2011. And as you read through the article later, my Lord, you will see further details about him joining the police in 2010, and that the explosion was, or the car bomb had been placed under his car outside his home. And in the final 2 paragraphs, my Lord, of page 360, if I could just direct your attention towards those momentarily, please. You'll see reference to Detective Chief Inspector John Caldwell as being the investigating officer, or the leading investigating officer, and we'll return to his name in due course in these submissions. Lord, if you would next then turn to page 322 and 323, please. Thank you, my Lord. And you'll see the title of this BBC article refers to David Black. He was a prison officer. If I may direct your attention towards the top of the second page, 323, the article begins, Mr. Black was driving to work at McGabry Prison when shots were fired at him from inside a passing car on the M1 in County Armagh on the 1st of November 2012. So here we have, my Lord, a sequence of incidents beginning with Constable Carroll, going on to Constable Heffron, going on to Constable Kerr, and now moving away from a police officer but to another civil servant, a prison officer who was targeted by dissident Republicans as a result of his employment. You will see in the open source materials from Lord, I won't take you to a specific page reference just at the moment, but reference to a second prison officer, David Ismay, who was again sadly killed as a result of a bomb which was placed under his vehicle on his way to work, and that was in 2016.
What was the year, sorry?
2016. And, my Lord, may I next invite you to go forward then in the bundle to pages 384 and 385, please. And again, you'll see another BBC article, my Lord. The title is on 384 as PSNI murder plot discussion recorded by MI5. The beginning of the article then on page 385 states, an undercover MI5 agent has told the court of how recordings were made of 3 men allegedly discussing a failed murder attempt on police. You have the accused names in the next paragraph. Then after that, some detail about the actual attempt itself. It says they face a range of terrorist-related offences connected to a gun attack on the PSNI in 2013. All 3 men deny preparing and directing terrorism and being in the IRA. Mr Fitzsimmons and Mr McCrory also deny attempting to murder police and possession of 2 AK-47 assault rifles and ammunition with intent to endanger life. The charges relate to a gun attack on a police convoy in the Crumlin Road area of Belfast on the 5th of December 2013. I'm going to ask, my Lord, that you next turn to the first part of the open source materials, I think bundle A for you, and it's a document entitled Report of the Independent Reviewer, and it has a page number 71.
Yes.
And my Lord, on that title page, you'll see the following detail. It's the Independent Reviewer's 10th report covering a period August 2016 through to July 2017. And the date of the report itself is April 2018. It's quite a substantial document, but if I may invite your attention respectfully to internal page number 6, inquiry page number 82, and paragraphs 4.1 through to 4.3.
Short interlude, could I indicate that there is a Spanish translation that is taking place for reasons that everyone will understand, and we've had a message from the Spanish translator asking if Mr. Henry could speak just a little more slowly. So it's not the volume; it's just the speed. Thank you.
So we were at paragraphs 4.4 and 4.5, Mr. Henry.
Yes, thank you, my Lord. So you'll see the title of Chapter 4 is Security and Public Order, and then the subtitle immediately below that is Security. The only detail that I would like to draw out of paragraph 4.1 are the reference to the 4 different dissident Republican groups in the first sentence. They as posing the threat. Moving down to paragraph 4.2, these groups have continued to target and attack police officers, prison officers, and members of the armed forces. And then the next series of sentences, my Lord, deal with the general threat assessment at that time. If I may then invite your attention down to paragraph 4.3, please. And I'm afraid the print quality is rather poor, my Lord, but it reads that during the report period, so August 16 to July 17, there were 6 national security attacks carried out by dissident Republicans. They involved a range of different methods. And then in the sub-paragraphs A through to D, we have a description of the type of attacks. So the first of those at A, August 2018, pipe bombs were thrown at PSNI, and it refers to that taking place in both Derry/Londonderry and Belfast. At B, it goes on to refer to January 2017. A police officer was shot and seriously injured in a shooting at a petrol station in the Crumlin Road area of North Belfast, when up to 10 rounds from a military assault rifle were fired at him. C, the top of the next page, deals with February 2017, and it refers to a PSNI officer on his way to work, narrowly having escaped serious injury when an improvised explosive device, which had been placed under his vehicle, failed to function as he drove off. The device exploded during the subsequent clearance operation, but there were no injuries. Below that, at D, in March 2017, dissident Republicans in Strabane detonated a roadside device in a residential area as a PSNI vehicle was passing. So, my lord, that gives us a flavour. Whilst we're not describing every single incident, that gives us a flavour of the period from 2009 through to 2017. I'm now going to turn to 2019, if I may, going back to Part B of the bundle. And page number 368 and 369.
I have those, thank you.
Thank you, my lord. And again, what you're looking at is a BBC online article. You'll see the date of the article is the 22nd of October 2021. But the date of incident that is referred to within the article is June 2019. And if I may invite your attention then to the top of page 369 and the second paragraph, you'll see a viable device was discovered by an off-duty officer at Shandon Park Golf Club in East Belfast on the 1st of June 2019. It goes on to describe Peter Granahan of Beleek as being charged with the attempted murder of a serving police officer. It gives further details about the suspect, and then in the sixth paragraph you will see the article reads, the police officer noticed the device attached to the underside of his vehicle when he returned from a round of golf. And that's something that I'm going to respectfully invite the inquiry to consider in due course, that as a result of these kinds of threats, the reality for both the serving officers and the former officers is that they have a very different security protocol. They are routinely checking underneath their cars. They're vigilant about the members of the public who are around them at all times. They're careful about their personal information. They're careful about who knows their name, who knows where they live, who knows who their family are, and so forth. I'm very conscious to protect that they are or were serving police officers.
You mean very different from members of the public?
That's correct. It's a different situation for them, and also a different mindset. So a member of the public, thankfully, doesn't have to operate in that same kind of security-conscious world as a serving or former police officer. So next, my lord, I'm going to respectfully invite you to turn to page number 191. I beg your pardon, my lord, page number 190. And the title of the document that you're looking for is Dissident Republican Attacks and Attempted Attacks in 2021.
Yes.
Now you have those attacks summarised in the table below the title, my Lord. The first attack was on the 16th of March. You'll see in the third column the location described as Enniskillen. The third column, attempted shooting attack, and in the fourth column, report of shots being fired at PSNI, Enniskillen, as well as the deployment of an improvised explosive device. No improvised explosive device was located, and an improvised firearm was located, which was assessed to have been used to fire a shot, and thankfully no casualties reported as a result. So that's the first of the two incidents. Secondly then, the date was the 9th of April. The location was Dungiven. The type of incident was an IED attack at the home of a police officer. And you'll see in the description summary, a crude improvised explosive device had been deployed to the rear of an off-duty police officer's vehicle in Dungiven, and thankfully it failed to function as intended. If your Lordship would then scroll down a couple of pages to the summary section for 2022, you'll see a similar table. It contains one incident, date being 15th of August, locations described as Londonderry, the incident type shooting at police, and then you will see in the final column, new IRA fired 7 shots at police close to an anti-internment bonfire in the Craiga area of Derry City. So that's 2022, my Lord. Coming forward then to 2023. May I ask that you turn up page 393, please.
I have that, thank you.
And the title of this BBC article is Dissident Republican Group Warns PSNI Families Are Targets. The date of the article itself is the 9th of March 2023. Within the body of the article, it reads, a dissident Republican group has warned that relatives of Northern Ireland police officers are considered targets. You'll see that that threat was made in a statement to the Irish News. The group responsible is referred to as ANP, and in the 4th paragraph on that page, my Lord, you'll see that ANP is a small group that was behind an attempted bomb attack outside the police station in Londonderry last November, so the previous year, 2022. You may also, my Lord, have seen reference to the bomb attack on the Bishop Street courthouse in January 2019, again in Derry City. My Lord, if I, just before I turn back to the other bundle, if I might take you to one further entry, a little further towards the back, beginning on page 409.
Yes.
And you'll see again a BBC article, my Lord, the title of which is Man Admits Recording Vehicles at Police Station. The date of the article is 16th of September 2024. The body of the article reads, a 33-year-old man has admitted recording details of vehicles parked within Lurgan Police Station on his mobile phone. And this is a detail, my Lord, I haven't drawn out in detail in the previous entries, but you will see the defence lawyer's name in the final paragraph on that page. You will not see the prosecutor's name, and that is not an unusual situation for that kind of reporting within this jurisdiction. It's something I'll return to in due course.
So that's a commonly reflected feature of courtroom news reporting, is it?
It is, my lord, but only in respect of terrorist offending. It's perfectly normal to see a prosecutor's name published in a news article for a non-terrorist offence. And Lord, if I may ask you then...
Sorry, Mr Henry, the point you're making is that contrasts with what one would find in other reports from the United Kingdom.
Indeed, my lord, it's a point I was going to come to within my skeleton argument that, and perhaps we could deal with it now, the types of security arrangements which are the norm within this jurisdiction are not replicated in other parts of the United Kingdom or indeed in the south of Ireland. Take, for instance, our judiciary. They are routinely flanked by two armed bodyguards and transported accordingly in a protected vehicle. Other high-ranking officials within the criminal justice system and in the public sector, again, are assessed as requiring those kinds of security arrangements, those kinds of precautions. That distinguishes this jurisdiction and the security arrangements which are the norm and are required, assessed as required, from other parts of the United Kingdom. So, my lord, may I ask you, before we leave this article, just to look at the next page, page 410. You'll see in the second paragraph that the accused pleaded guilty, and below the subtitle CCTV footage, it reads, he was further charged, this being the accused, that on the same date he published information about two people who are or have been members of His Majesty's forces, namely vehicle details of two individuals who are members of the Police Service of Northern Ireland, which was likely to be useful to a terrorist. So here we have someone proactively seeking information from in and around a police station, vehicle registration details, recording them, and then publishing those details in such a way that they would be useful to terrorists. And Lord, I wonder then if I might ask you to go back to the hearing or trial bundle, please. And I'll round off the reference now to the open source materials, just by reference to a couple of further news articles. Page 189 and 190 to begin with. And what your lordship should hopefully have in front of you is a BBC article which has the title, Omagh Police Attack. John Caldwell has suffered life-changing injuries.
Sorry, Mr Henry, I'm looking in the wrong bundle.
That's quite all right.
Yes, I have it. Thank you.
Thank you, Lord. So this is the officer that I mentioned as the investigating officer in one of the previous newspaper articles or online articles that we've gone through. Detective Chief Inspector John Caldwell, as he was during the course of his service, operated in a MIT, or Major Investigation Team, and was the lead officer in many investigations into terrorist offences. And with that in mind, with that context in mind, my Lord, I would invite you to look at the top of the second page, 190, where it reads, Detective Chief Inspector John Caldwell was shot by 2 gunmen after coaching children at football on Wednesday. Police said he was with his son, putting balls into the boot of his car, when he was shot at 2000 hours, Greenwich, 2000 hours, I beg your pardon. Mercifully, my Lord, Mr. Caldwell survived his injuries. Goes on down through the article to describe him as being in a critical but stable condition at that stage, and he had to retire from service shortly thereafter as a result of those injuries. So, just pausing there for a moment, my Lord. From the open source materials that you've seen so far, you have quite young constables starting at the beginning of their career who've been targeted in assassination attempts. You have senior officers right at the top of the Major Investigation Team being targeted in assassination attempts. It is self-evident from the short descriptions of those attacks that they were planned attacks, that information had been gained and gathered, perhaps systematically, in relation to the targets of those attacks. There was no discrimination between the particular role that the officer played or the seniority of the officer. And, my Lord, if I, just remaining with Detective Chief Inspector Caldwell for a moment, if I may ask that you go to pages 167 and 168 of the same bundle.
Yes.
And the title of this BBC article is Controversial Bonfires Are Lit in Londonderry Amid Criticism. And I would ask your Lordship just to note the date below the image of the bonfire on the first page. That's the 15th of August 2025. So this is approximately 2 years after Detective Chief Inspector Caldwell has been shot and seriously injured, and he has retired. And as you read through the article, you will see reference to both a serving officer's name and also John Caldwell's name appearing painted onto a pallet placed on the side of the bonfire before it was set alight. If your Lordship looks over the overleaf to page 169, you'll see an image of what appeared on the side of the bonfire. You will see John Caldwell's name, which was previously known. The serving officer's name has obviously been blurred out below that, and you'll see the rather menacing crosshairs of the target beside those names. So, my Lord, that's a threat that exists to Mr. Caldwell some period of time after he's already been shot and after he's retired, and also for that serving officer whose name's pixelated. The last open source item that I'm going to ask you to look at is an article on page 173 and 174, again in the same bundle.
Yes.
And if I can orientate you through this, my Lord, on the left hand, or on the first page, you'll see the date of the article, the 4th of July 2025, just above the image of the wildlife camera. What you're about to read is two dissident Republicans who had secreted a wildlife camera in the driveway of a retired police officer with a view to gaining information about his pattern of life on which to mount an assassination attempt. So just to bring you through some of the core detail of this article, my Lord, below the image, you'll see it reads, 2 men were found guilty today of terrorist offences, including targeting a retired police officer. That's the first paragraph. The third paragraph gives the names of the defendants, Damien Duffy and Shay Reynolds, and that they were convicted of 6 joint offences committed over a time frame 3rd to the 21st September 2016. They were convicted of offences of preparation of terrorist acts, 2 counts of possessing articles for use in terrorism, and 2 counts of attempting to collect or make records of information likely to be useful to a person committing or preparing an act of terrorism. In the paragraph below that, you'll see reference to the wildlife camera that the 2 of them secreted in the the hedge of the driveway. You'll see reference to the driveway in the next paragraph at the top of page 174. It reads, it was then deployed in the driveway of the home of a retired police officer referred to by the judge as Mr. X. And my Lord, I made the observation in relation to the description of the prosecutor versus the description of the defence barrister in relation to one of the previous articles. You'll see that borne out in this Belfast Live article. In the penultimate paragraph of the second page, that's page 174. Or I beg your pardon, the third and second last paragraphs. So, my Lord, just before I turn to the JTAC assessment document, I'm respectfully going to make some observations in relation to that material. First of all, we know from the Article 2 test that it must be a risk of death, otherwise Article 2 cannot be engaged. You can see readily from the open source materials that I've rehearsed to you, they are all shooting and bomb attacks or preparation for such attacks. So the consequence, if successful, and tragically they were successful on a number of occasions, is the loss of life. So we know that we're dealing with a risk of loss of life. It didn't matter whether the officer was on duty or off duty. It doesn't matter whether the officer is serving or retired. It doesn't matter whether the officer is young or old. It doesn't matter which role within the police service the officer is, in which the officer discharges their duties. They are all potential targets of shooting or car bomb attacks. And what we respectfully suggest to the inquiry on the basis of that material is, before we come to the JTAC assessment, there is obviously a real risk to the lives of both serving and former police officers. The reason that I've gone somewhat laboriously through the chronology, my Lord, in terms of year by year, is to illustrate to this inquiry that it is both an historic threat, with reference back to the 300 deaths described by Lord Carswell in Re Officer L, right through from the period of time beginning in 2009 to 2025 that I've just taken you through. It's a threat which has existed throughout that entire period and continues to exist. And, my Lord, just in case the court has any reservations about reliance on those kinds of open source materials, I'm going to ask that you turn up page 114 of the hearing bundle, please. And what I'm going to take you to is a portion of the PSNI's written submission. And in particular, paragraph 72, so page 114, paragraph 72. And the reason I've taken you to this is below that paragraph, you'll see a quotation from the Ballymurphy inquest decision of Mrs. Justice Keegan, as she was then, now Our Lady Chief Justice. And this was made in the context of the anonymity applications by the former police officers and soldiers in that inquest. So if your Lordship has that available to you, paragraph 23 of Mrs. Justice Keegan's findings stated as follows. Of course, the present evidence relates to an ongoing dissident threat that has been evidenced by a number of incidents in Northern Ireland, and I was provided with press briefings in which that threat was very definitely described as real, continuing, and present. So it was clear that Article 2 is engaged in these cases. In addition, there are common law powers to protect witnesses where appropriate, which I utilise particularly when dealing with medical vulnerability. The point I'm respectfully making to the inquiry is this. On the open source materials alone, the Article 2 test of real and immediate threat or risk of loss of life is made out. I respectfully now turn to the JTAC assessment. Mr. Greeny's already touched upon this.
I wonder if I could interrupt Mr. Henry for a moment. So, as we did this morning, we will need a short break so that it's not going to have a rest. So could we break now, if that suits Mr. Henry, as I think it will, for 15 minutes?
Mr. Green.
Bearing in mind the submissions that you still have to hear on this important issue, it's plain that we will not conclude the hearing by a reasonable time this evening. And we know that you will be very keen that no one should feel rushed in the submissions that they make. And it seems to us in the circumstances that, bearing in mind that we will have to come back tomorrow to conclude this hearing now, that the sensible point at which to stop. The sensible point at which to stop is once you have heard from Miss Fee. So you would then have heard from the state court participants, and we would start tomorrow morning with the submissions on behalf of the family court participants who have lodged written submissions. Subject to your better view, sir.
Well, I see the sense of that suggestion, Mr. Greenie, but let's just leave it open until we see what time it actually is.
Of course. We see the sense in that. Thank you.
Mr. Henry.
Where we left off was at the JTAC assessment, which has been touched upon briefly already. May I ask you to open up the hearing bundle?
Is that any better?
So should I, can you hear me okay? And can I check whether you can hear me now? No. You can hear me now? Yes. Good.
All right, Mr. Henry, thank you for your patience. Would you mind just commencing your submissions again?
Thank you, my lord. So I'm taking you to the JTAC assessment. I won't open a separate document to you, but I would just flag up page 152, which is the statement of the Detective Chief Superintendent of Intelligence Branch in the PSNI, who provides the inquiry with some background information about how these assessments come to be compiled. And just for the benefit of the core participants, I know the inquiry tomorrow or some subsequent day will see the closed version of the JTAC assessment, which contains all of the formalities with such a document that one would expect. What the CPs are seeing is the extraction of open data or information which is capable of being shared in open and simply put onto an A4 page. I know some of the core participants had made the observations about the lack of signatures, statements of truth and so forth in relation to the assessments. And I hope that goes some way to reassure them that there's more formality to the closed version, and there's an explanation as to why they're seeing it in this format. So if I could ask that you look at the top of page 210, please. And what you have here, my Lord, is the overarching Northern Ireland-related terrorism threat level in Northern Ireland, and it's currently assessed as substantial. And that translates to meaning that an attack is likely or an attack is probable. One of the things I'm going to ask the inquiry to consider in due course is the likely target of that attack or attacks. And it's going to become, if it hasn't already, it's going to become quite plain that members of the security forces, including and perhaps in particular police officers and former police officers, are the target or intended likely targets of those attacks. So below that, my Lord, we see an intelligence summary and incidents section, and it states dissident Republican groups have never conducted an attack against a witness in an inquiry or inquest in Northern Ireland. An obvious point to make in an assessment such as this, and one which some of the core participants have picked up upon within their written submissions. One of the respectful observations we make about that, my Lord, is whilst not every single application is granted, it is not infrequent that members of the security services and former members of the security services are granted anonymity in inquest and inquiry proceedings in this jurisdiction. And therefore, the absence of attacks against those individuals, we say respectfully, is in part due to the fact that they are frequently granted anonymity.
Mr. Henry, just sometimes you let your voice drop a little. Can I encourage you, given the distance we're apart, and...
Certainly, my Lord. I understand. So if I may move on to the final subcategory then of the JTAC document. The title is Dissident Republic Intent and Capability. And it begins by stating, if a witness who is a former member of the RUC or PSNI has their identity made available in the public domain. This will likely increase dissident Republican intent and capability to target that individual. So we know so far in this conclusion section that the intent and capability of those who pose a threat to the former officers will increase if their identity is made known. And continuing with what it states in the assessment, due to the extensive media coverage, dissident Republicans likely have an awareness of the inquiry, and there is a realistic possibility that dissident Republicans will speculate on the identities of certain witnesses. Another way of describing that is that there is a real possibility that they will attempt to identify those former police officers involved. The assessment continues then. Dissident Republicans have proven that when they are able to successfully identify an individual and obtain sufficient targeting information, I'm just pausing there to emphasize that it is not just the pattern of life type movements, where the individual lives, what kind of car they drive, where they socialize, where they work, also their name, which is useful to subversive elements in trying to tie together those details and perhaps research further in the modern world of social media and lots of electronic databases. So dissident Republicans have proven that they are able to successfully identify, that when they are able to successfully identify an individual and obtain sufficient targeting information, such as home address, vehicle details, or pattern of life, POL, they possess the capability to successfully translate this into an attack. And my Lord, we respectfully refer back to the variety of open source materials which make good that statement within the assessment. The penultimate paragraph reads, dissident Republicans highly likely view former members of the RUC and PSNI, and therefore former RUC and PSNI witnesses at the inquiry, as legitimate targets for attack. So we lay emphasis on three elements. First of all, it is former RUC and PSNI officers. Secondly, that they may be seen as legitimate targets for attack, and the inquiry so far has heard multiple examples of such attacks, sometimes fatal, thankfully other times not. And the third observation that we lay emphasis on here is that it is highly likely those individuals will be seen as legitimate targets. So a high degree of probability. The final paragraph reads, should any former RUC or PSNI witnesses at the inquiry be denied requested measures such as anonymity and screening, there is a realistic possibility the Northern Ireland-related terrorism threat to those individuals will increase. I'm just pausing there for a moment. That is a material increase, we respectfully suggest, my Lord, or rather, that is evidence of a material increase. One could say that the threat is pre-existing. The test is whether the giving of evidence that creates the risk or materially increases the risk. Here we have objective evidence that there will be a material increase in the risk if the former officer gives evidence without anonymity. And finally then, the assessment concludes with, however, any increase in the level of threat is dependent on the receipt and nature of any subsequent intelligence. And my Lord, just before I move on to address some of the queries that you raised, or Mr. Greenie raised from his helpful observations earlier, I'm going to invite the inquiry to take the following submission into account. There is an institutional competence within this assessment. It has been undertaken by those who have expertise in judging what the actual threat is. And they have drawn on the appropriate sources of information to make that assessment. I made the observation earlier on that inquiry may be satisfied on the open materials alone, that the Article 2 test was met in relation to the officers. We respectfully suggest to the inquiry that JTAC assessment dispels any suggestion that the test could not or is not met in the case of all 5 officers. An attack is likely. They are the likely targets of such an attack. The attack, if successful, will be fatal. And there is a material increase in the risk to the retired officers as a result of giving evidence to this inquiry without anonymity. And one of the queries raised was, this is a general threat assessment covering all former or retired police officers within Northern Ireland. It does not deal with the individual, so it does not deal with Officer 1, 2, 3, 5, or 7. And our respectful submissions in response to that are as follows. So firstly, it is by its very nature a general assessment. It covers all 5 of those officers as a result of them being former officers. There is no requirement for an individual assessment to arrive at the same conclusion in relation to them. It is setting a base level or baseline assessment in relation to former officers. Some of those individuals or some of the officers may be at higher risk. Some may be in comparison to one another. Some may be at lower risk in comparison to one another. But what we respectfully say is that on the basis of this JTAC assessment alone or coupled with the open source materials, the test is met in respect of them, whether they're at the top end of the risk spectrum or slightly lower down. But it's covering a range of different officers. The second observation I have to make in relation to the suggestion of individual assessments is this. You have the benefit of individual open and closed witness statements from each of the officers. You're setting out both their personal experiences in relation to their service and the security issues which have arisen from that, and also the effects, perhaps more pertinent to the common law test, but the effects that the fear has had on them and their lifestyles. So you are not deprived of individualized evidence in respect of each of the 5 sample applicants. You have a overarching general threat assessment, and then you have individual detail about each of the 5. One of the other queries that was raised, my Lord, was to deal with the issue of why, or the significance rather, of some officers requesting anonymity and others not at all, and some requesting anonymity to the public at large, but not the 4 participants. So what we say in relation to that, my Lord, is as follows. Firstly, it is a personal choice on behalf of each of the individuals involved as to whether or not they ask for anonymity and whether they ask for it against the public at large and the core participants or only the broader general public. Their own personal decisions will be informed by their circumstances. It may be informed by things such as their profile, such as their own personal risk tolerance, or some other reason specific to them or combinations of reasons to them. Whatever the reasons for their choices, my Lord, we say respectfully, they're largely irrelevant. If the Article 2 test is met, and they ask for anonymity, we respectfully say that they're entitled to it. Some may choose not to, but if the test is satisfied and they apply, they're entitled to it.
if the Article 2 test was met, there would be an obligation on me to take steps of some sort. Would I then be bound to shape those tests around the individual preferences of the witness? Or might I, in fact, conclude that the steps which ought reasonably to be taken were greater than they had suggested?
You would be so entitled.
Sorry?
You would be entitled to reach that conclusion.
Because it's for me to assess what the reasonable steps require to be.
I don't disagree at all with that, my Lord. One of the respectful submissions I'm going to make to you is this. When we come, and I appreciate that there is some nuance to this, which the court will wish to address in relation to individuals in due course. But when we come to the decision of Mr. Justice Humphreys in the Coke inquest, he talks about the grant of anonymity as being the minimum reasonable step in response to Article 2 being engaged. We respectfully endorse that approach to that test, and we invite the inquiry to adopt it as well.
I think it's the same approach that Mr. Justice Horner took
in the Jordan
yes. Case as well.
And he was taking his lead from the decision of Justice Carswell in Re Officer L as well, and interpreting his comments as in paragraph 29 as anonymity being the baseline, as Mr. Justice Horner described it. So, unless your Lordship has any further queries just in relation to those discrete issues, what I'm going to do now is move on to what we've referred to in the written submission as the Northern Ireland context. I've deliberately taken the inquiry through the evidential materials, first of all, in order to build up for your benefit a factual background in which to understand how the Judicial Review Court, the coroners within this jurisdiction, and most importantly the Court of Appeal have arrived at their respective decisions in anonymity cases. As you may have noticed from the written submissions and the authorities bundle, my Lord, there are a huge number of anonymity decisions emanating from this jurisdiction from all different types of case. We've attempted to summarise some of them in that table which is annexed to the end of our written submission. I don't intend to go through that with you, but it's just to demonstrate quite how often this issue arises within the Northern Ireland context, and also quite how often the anonymity applications are successful because of the factual context in Northern Ireland, and in particular the security situation. So, my Lord, I'm next going to ask you to turn to my written submissions, please. And if you just bear with me one moment. Page 127 of the hearing bundle. You'll forgive me, my Lord, if I touch upon some of the territory that Mr. Greeny's helpfully outlined already, but I'll do so in as brief a manner as I can. So paragraph 114 of the written submission, you'll see, has a subtitle above it, Northern Ireland Context. And we have described this as being an issue which has plainly exercised the Court of Appeal in multiple different cases in relation to the application of the Article 2 test when former members of the security services, in particular police officers, apply for anonymity. What we said in the second half of paragraph 114 is that whilst it is imperative that each application is considered on its particular facts. The two reasoned judgments, and this is in reference to the Court of Appeal's decision in C, 2012, the two reasoned judgments made it clear that such applications were likely to succeed as a result of the security situation in Northern Ireland and the particular risk faced by members and former members of the security forces. And over the page, my Lord, what we touch upon, and this resonates with what of the summary that Mr. Greenie gave earlier. The security situation in Northern Ireland is different to other parts of the UK. The laws that applies is exactly the same. What changes is the factual context. And that's why we observe that in practical terms, what that results in are differences in the security arrangements. So the security around courtrooms, the security around judges, security around public officials, the security around high-ranking members of the criminal justice system, and indeed some prosecuting counsel as well. And we observe at the bottom of paragraph 115, my Lord, that those types of security arrangements are not commonplace, in fact, largely non-existent in other parts of the UK. It's because the security situation here is different. The consequence of that, in terms of anonymity applications, is that they are frequently granted. I'm going to ask the court respectfully to look down at paragraph 117 of the written submissions, where we've quoted from Lord Justice Girvan's judgment in the C decision, 2012. And Mr. Greenie has helpfully identified this as a pertinent paragraph already. What I would like to draw out with some emphasis, Lord, is on in the latter half of that paragraph. In the written submissions, you'll see it highlighted in bold. After talking about the threat to the general public from dissident Republican attacks, Mr. Justice Girvan went on, or Lord Justice Girvan went on to say, for some, such as members of the police force, the level of threat has been and continues to be at a much higher level and is much more immediate. It cannot be considered as anything close to fanciful, and it is significant. So in simple terms, my Lord, what the court is conveying there is the real and immediate test is satisfied. The court goes on to say the requirement to give evidence imposed...
Mr. Henry, can we just pause there for a second? I'm just slightly confused about something. Give me a moment.
Certainly.
The quotation from Lord Justice Girvan's opinion, which appears there, is said to come from paragraph 43 of his decision. In the report that I have, it seems to come from paragraph 71.
If we've made an error, my Lord, in our drafting, we apologise for that. Perhaps that's something that I could address at the end of the submissions, and Mr. McCartan will assist me with that, and we'll make sure that we've given you the correct paragraph number at the end.
Unless I'm looking at a report in a different publication from the one that you've quoted from.
It may well be in that your Lordship's looking from the Northern Ireland law reports rather than the neutral citation judgment, but that's something we can easily resolve. Anyway,
I've located the precise comments in my copy that you're relying on.
Thank you, Lord. I apologise for any confusion arising there, my Lord.
No, it's perhaps me that's looking at a different version of the opinion.
And my Lord, I normally wouldn't take a court or a decision maker through authorities within the body of a written submission, but the authorities bundle was so substantial, I thought it might just be easier and more convenient to do it in this fashion.
Yes.
So, Lord, where I left off was at the word significant, 5 lines from the bottom of that paragraph.
Yes.
And Lord Justice Girvan, as he was then, continued, the requirement to give evidence imposed on officers involved in this inquest will, according to the evidence, so the assessments that were given in that case, including a general threat assessment, will increase a present threat, pausing there, that is sufficient to satisfy the second limb of the test, present and continuing. But the court goes on to say it may increase possibly significantly, depending on the nature of the evidence and other unknown contingencies arising out of the inquest. The risk accordingly must qualify as real, continuous, and present. I think the point the court was making there is that one witness's evidence may be more controversial than another, but the threat to the applicants in that case was real and immediate, so more than trivial or fanciful, the first component, and present and continuing, the second component. And similar comments, my lord, are made what I hope is paragraph 46 of that judgment. You'll see it in the second half of page 129 of my written submissions. And if I could draw your attention to the first 6 lines of that, please, my lord. So this is a quotation which appears below paragraph 118 within the written submissions. It reads, against that fluid and unpredictable background, and in the context of an ongoing terrorist campaign in which police officers very much remain as higher risk targets compared to the general population, the evidence points, in the words of Soaring, so that's a Soaring v UK case, to substantial grounds for believing that they faced real risks of a murderous attack. The risk could not be dismissed as fanciful, trivial, or the product of fevered imagination. A little crossover, my lord, I think potentially there between the Article 2 and the common law test and the type of language which is used, but the point is that the court was stating in very clear terms that the risk was real. As your lordship will know from having reviewed the authorities already, there were 3 judgments of the Court of Appeal in that case. There was Lord Justice Girvan's reasoned judgment. There was Lord Chief Justice Morgan's reasoned judgment. The 2 agreed with one another. And then there was Lord Justice Higgins as well, I believe, who agreed with both in a much more concise judgment. I'm just going to touch upon Lord Chief Justice Morgan's decision, if I may, and paragraph 27. And again, I'm going to take you to that through the written submission. So at the bottom of page 130 of the written submission, please. The point I'm about to make, respectfully to the inquiry, is this is a second Court of Appeal judgment stating that in the security situation within Northern Ireland, it is unsurprising that anonymity applications are frequently granted for former officers, because in this case, they were dealing with former police officers as well. So at paragraph 27 of Lord Chief Justice Morgan's judgment, he stated, in Northern Ireland, there is, however, a particular context. Police officers have been subject to threats, targeting and attacks by well-organised and resourced terrorist organisations using lethal force for many years. It is hardly surprising, therefore, that where the threat emanates from such a group, the Osmond test should be more frequently satisfied. I'll make a few further observations about the Northern Ireland context, my lord, if I may, through the Coke judgment, which you'll see is the next case listed within the written submissions. Really, the value to the inquiry, we say, from that judgment is, firstly, It shows the application in real terms of the guidance provided in C, so Lord Justice Skirvin and Lord Chief Justice Morgan's recent decisions. And secondly, we see a repetition of the precautionary principle being applied, which emanated from a couple of inquests prior to the Jordan inquest, but ultimately arrived in the written judgment of Mr. Justice Stevens, as he was then in the Jordan inquest. So with that, my Lord, I respectfully ask that you turn the written submission over to page 133. And at the bottom of page 133, you'll see the beginning of what Mr. Justice Stevens said in Jordan, and in particular paragraph 118 of his decision in that case. It was a judicial review of the inquest, the coroner's decision. And it reads as follows: in carrying out a precautionary approach was adopted by Mr. Justice Weir in his decision dated the 29th of October 2013 in the inquest into the death of Roseanne Mallon, the 20th of the 5th, 05. A similar approach was adopted by Mr. Justice Deeney in his judgments dated the 17th and 18th of September 2012, and the citation is given at paragraph 101. And here's the important information, my Lord. A precautionary approach is not acting without evidence or good reason, but rather involves recognition that A, on one side of the balance, the public authority is dealing with the potential for a catastrophic loss of life, and or B, the public authority is having to anticipate prospectively in circumstances where events at the inquest and the consequences of a result may not be predictable from all of the subjective perspectives in play, including those who would carry out murderous attacks. So in simple terms, it's difficult to anticipate precisely what will happen during the course of the proceedings. It's also difficult to predict what the dissident Republicans who are posing the threat will do. And we respectfully observe that it's perfectly understandable why the precautionary principle has worked its way into the jurisprudence within Northern Ireland, given the significant consequences of what can result. The second and final thing I would like to draw out of the Coke judgment, my Lord, is below at paragraph 135 of the written submission, and it's paragraph 16 of Mr. Justice Humphrey's ruling in Coke. He delivered two rulings on anonymity applications in that inquest. One was to do with former soldiers and one was to do with former police officers. This was the decision in the application relating to the police officers. And I'm going to draw your attention in particular to 16 Roman numeral 1, but I'll read out what comes before that first. I have taken all of the generic evidence into account in the respective individual applications. I have applied the precautionary approach in analysing each, and am cognizant of the following. If either the common law test is satisfied or Article 2 is engaged, then anonymity is the minimum protection which the court should afford. So your Lordship queried a moment ago about the duty, if Article 2 is engaged, the duty being to adopt reasonable steps to protect life. What Mr. Justice Humphreys is saying is the grant of anonymity is the minimum reasonable step that should be granted. There may be further derogations in individual cases, which is appropriate. By that I mean derogations from the principle of open justice. So things like screening and so forth, but we haven't reached that point in this inquiry yet. He's saying the name, anonymity, is the minimum reasonable protection. And as your Lordship observed earlier, that's been repeated by Mr. Justice Horner in the Jordan inquest findings as well. So I'm going to leave, and Lord, my submissions in relation to common law, the common law test will be much briefer, but just summing up in relation to Article 2, as I've said already, there must be a real risk. That is a risk which is more than fanciful or trivial. We say that is obviously satisfied on the general open source information, the general threat assessment and the individual circumstances. And that risk must be immediate, namely present and continuing, again, readily made out. We point out that an attack is likely, an attack, if successful, is lethal. The police are the likely targets of that attack, and the refusal of anonymity increases materially the risk of such an attack to the individual witness. Just before I touch on the common law test, one issue that I know the inquiry will be interested in is some of the officers or former officers having given evidence under their own names previously. And in due course, whilst I won't read it out to the court now, I would invite your attention to what Mr. Justice Deeney said about that in the first instance decision of the C case, and in particular at paragraph 90. My respectful observation at this stage is more basic than that of Mr. Justice Deeney. If the Article 2 test is satisfied, if you are satisfied there's a real immediate risk, and that the giving of evidence without anonymity would either create or materially increase the risk, the test is satisfied and the application should be granted. If the officer has given evidence before, they may, under their own name, he or she may have increased the risk to them as a result of that. But the Article 2 test, we respectfully say, can be considered separately. And where the giving of evidence under one's own name previously may have more purchase in the inquiry's mind is under the common law test when arriving at the appropriate balance of fairness. So, my lord, the common law test then, we know, and there doesn't seem to be any controversy in relation to this, but at its core is the issue of fairness, and it includes fairness to everyone involved, including the former officer who is seeking anonymity. Officer L, paragraph 22, explained that where such such applications are made and involve fears of the individual officers, the requirement is to apply anxious scrutiny to the application. And there arises a balancing exercise between the fairness to the individual versus the fairness to the inquiry and the others involved in the inquiry. One of the most prominent considerations in that balancing exercise, not the only, but one of the most prominent, will be the subjective fears of the individual. And we're relying in particular on the words of Lord Chief Justice Wolfe in the Saville decision from 2000. Now, what about those subjective fears in respect of officers, the 5 officers who are making the application in this inquiry? The first thing this inquiry will need to consider is, are they well-founded? We rely on the open source material, the threat assessment, and the individual statements of the officers to demonstrate compellingly that they are well-founded concerns. Each of those officers has spent their entire career under a general degree of fear, and that has continued into their retirement. And other considerations that the inquiry will be taking into account are the speed and ease with which information is shared in the modern world, in particular social media, but not exclusively. And in our skeleton argument, we referred to paragraph 19 of Mrs. Justice Keegan's decision in the Ballymurphy inquest, where she talked about that as being a relevant consideration in the common law context. The inquiry will want to take into account how significantly, if at all, a grant of anonymity, particularly when ciphers are applied, would impede the inquiry fulfilling its terms of reference. We say quite simply it wouldn't. And we also respectfully make two further submissions. Firstly, if the officers are not in fear, the inquiry may well feel that the quality of their evidence is likely to be better. And secondly, we rely on the chilling effect on others if anonymity is not granted, and in particular the Detective Chief Superintendent's statement at page 152, or page 153, where he comments on the effect on others, other police officers, and the difficulties in recruiting them to engage in sensitive roles if anonymity is not granted. And so, my Lord, drawing to a close in relation to the common law test, we respectfully say the inquiry doesn't necessarily need to consider it. There is ample evidence upon which to be satisfied that Article 2, the Article 2 test, is met in relation to all 5 applicants. But if the court did have recourse to the common law test, the correct balance would fall in favour of granting anonymity to the extent that each officer requests. Relevant to that, my Lord, is an observation made in one of the CP's written submissions, the Fox Law submissions, and the issue that's been raised is the value in a name. So we know that Lord Chief Justice Wolfe, in the Saville inquiry decision, queried the value to the inquiry and the participants in the inquiry of a name of an individual if they are ciphered, versus the value to the individual of a grant of anonymity and the fear that would be caused to them relevant to the common law test. And the Fox Law submissions quote a number of cases in which they talk about the value of a name being included in press reporting of court proceedings. What we would respectfully invite the inquiry to do when analysing those decisions is think about the context. The cases quoted are talking about Article 8 rights and Article 10 rights. They're not talking about fear of death. They're not talking about the fears arising in the context of an Article 2 / common law application for anonymity.
Indeed, in Guardian, Lord Roger specifically separated the two out.
And therefore, the appropriate guidance to follow, we respectfully say, is in the Saville decision. So, Lord, drawing to a close, I'll just make a couple more observations about the Fox Law submissions as briefly as I can. The submission was made that the fear of the police officers was irrational. The 5 officers who are requesting anonymity.
Sorry, just give me a second. I didn't quite catch that.
The submission was made that the fear was irrational. We say that
this is the Fox Law submission.
That's correct. And we say simply, in light of the evidence which I've taken some time and care to go through with you this afternoon, and the time for which we are grateful, that submission simply cannot stand. The second submission arising from that in the Fox Law document is that because the fear is irrational, the PSNI should reassure the police applicants or former officers that they are not actually at threat. And we fundamentally disagree with that. We say the evidence paints a compelling picture that there is a threat. And the suggestion has been made, my Lord, that what if the details are only disclosed to, the name of the officer is only disclosed to the CPs or only disclosed to the CP's lawyers? And whilst that is sufficient in many respects for non-sensitive materials, the protection which is in place is the undertaking and to some extent professional obligations as well, my Lord. When you're dealing with an Article 2 risk, that is not an adequate protection. And again, we point to the difference in behaviour between individuals who are routinely security conscious and those who are not. Nobody is making any suggestion that information would be deliberately disclosed. That suggestion is not made for a second. But inadvertent mistakes can happen. Papers can be lost, papers can be set aside, somebody can say the wrong thing in the wrong company, not realising who is listening. There's an infinite number of possibilities. But the undertaking itself doesn't provide adequate protection. So, my Lord, you've been very generous with, and as have my friends, with the time afforded this afternoon. We're grateful for that, but those are my respectful submissions.
Thank you very much, Mr. Henry.
Well, my Lord, next we have scheduled Ms. Fee on behalf of His Majesty's Government. We're not far short of 4:30. What I don't know for certain at any rate is by what time Ms. Fee thinks she would finish if she started now. That may determine whether you hear from her now or tomorrow morning.
Well, Ms. Fee, first of all, would you be content to make submissions this afternoon?
Mr. Chairman, I think it'll be about 10 minutes. I'm conscious that Mr. Henry has covered much of the ground that I might otherwise have covered, and Mr. Greenie similarly has covered much of the legal principle that I might otherwise have covered. So I'm in your hands, Mr. Chairman. I estimate it'll be around 10 minutes.
Well, I'm very happy to hear your submissions if you're content to present them today.
Thank you, Mr. Chairman. Mr. Chairman, you have the detailed written submissions on behalf of HMG, and they appear starting at page 211 of the bundle. And those submissions are accompanied by, following immediately afterwards in the same bundle, at page 229, an open witness statement from a GCHQ witness, and starting at page 232, an open damage assessment in respect of the UK intelligence community or UKIC witnesses. So those are the open documents, Mr. Chairman. HMG welcomes the Chairman's approach of seeking to give early decisions and directions to core participants, and appreciate the opportunity to make a representative anonymity application. As is set out in the written submissions, the government anticipate that almost all current and former UKIC, UK intelligence community staff, and those in other parts of HMG with similarly sensitive roles will seek protection of their names and designations, including cover names and other personal identifying information. The inquiry's helpful approach of facilitating representative anonymity applications will allow these issues to be explored in the context of the UKIC witness from GCHQ, who has provided the statement which I've referred to. HMG envisages that the issues raised in this representative application will be common to many individuals in a similar position. And dealing with issues common to multiple prospective applicants will result in significant advantages in terms of avoiding delay and unnecessary duplication of extremely similar arguments. The reason, Mr. Chairman, that many of the issues raised in the representative application will be common across UKIC is because of the similar sensitivities inherent in how these jobs are performed and the similar risks that attach. The cohort-based representative approach formulated by the inquiry has significant advantages over a witness by witness, individualised and fact-specific approach. So while, Mr. Chairman, you'll have the benefit of witness-specific information and a closed statement has also been served, the general concerns are common across the UKIC witnesses. I won't, Mr. Chairman, take any time in relation to the legal principles and the public interest test, which can be found at page 213 to 216 of the bundle in HMG submissions. But I would simply draw your attention, Mr. Chairman, to the fact that the HMG submissions at paragraph 15, which is at page 216 of the bundle, highlight the important recent Supreme Court decision in a matter which arose from the Thompson inquest. And that authority, I won't open it, Mr. Chairman, unless you wish me to, but it's at page 1065 to 1106 of the authorities bundle. And the Supreme Court carefully explained the role of the Secretary of State in making assessments in relation to national security. That's paragraph 35 or 38 of the judgment. And we've set that out in the submissions at paragraph 15, Mr. Chairman. It stated, further, the Secretary of State has the political authority and responsibility to make that assessment. In assessing national security, it is the Secretary of State who has the democratic authority and institutional confidence to make the relevant assessment, and the degree of respect due to be given to his assessment by a court has to take account of this. And as you'll be aware, Mr. Chairman, it's in a slightly different context in that that arose out of a matter from the Thompson inquest involving whether or not a gist should be disclosed, but you may feel that there is nonetheless some helpful parallels which can be drawn. In the same judgment at paragraphs 49 to 52, and that's at page 1081 of the authorities bundle and set out at paragraph 16 of HMG's submissions, the court considered the minister's assessment of whether disclosure of, in that case, a gist would cause a real risk of serious harm to an important public interest, which is, of course, the PII test. And the court noted that the minister's assessment of the threat from terrorism was that for a number of years there had been in the United Kingdom, and in particular in Northern Ireland, a very serious threat posed by terrorist organisations actively engaged in campaigns of violence. The minister recognised that the majority of these terrorist organisations in Northern Ireland were observing ceasefires, but nevertheless, he asserted that the threat of terrorist violence remained, and residual terrorist groups continued to regard violence as a way of furthering their objective. He assessed that any disclosure of the identities of individuals working to counter terrorism, as well as any disclosure of the tactics, techniques or procedures used, would damage capabilities for countering terrorism in Northern Ireland. So I simply draw that to your attention, Chairman, as a very recent decision which may prove of some assistance. I won't, Mr. Chairman, take you through HMG submissions about Article 2 and the common law. I think those largely echo what has already been heard from both of my learned friends in relation to the Re-Jordan application, Re-Seas application, and other cases, particularly in a Northern Ireland context. The precautionary approach, similarly, Mr. Chairman has already heard about in detail. That also is referenced in the HMG submissions. Moving on from the Article 2 arguments, Chairman, you'll find starting at page 221 of the bundle and paragraph 26 of HMG submissions, HMG has sought to draw out paragraph 28 the principal competing public interest factors for consideration if, Chairman, you get to the balancing exercise stage. And some of those are listed in the Inquiries Act itself, under section 19, and those include the need to allay public concern, the need to avoid or reduce the risk of harm to the relevant staff, and the risk of damage to national security. But you will see, Mr. Chairman, that the HMG submissions, while they deal with those matters, for example, public concern is dealt with starting at paragraph 32, they also have sought to draw out other interests which may be relevant. So it's recognised that the interests of the families will be something that you will wish to consider, Chair, and that is dealt with paragraph 35. One matter which has arisen in some of the core participant submissions has been the extent to which alternatives to restriction orders have been considered. That is dealt with starting at page 227 of the bundle and paragraph 55 under alternatives to restriction orders. HMG's position is that the sensitivities attached to the names, designations and cover names of UKIC staff and those in other parts of HMG with similarly sensitive roles are such that there is no alternative mechanism which can provide adequate protection. And Mr. Henry has already made submissions about inadvertent disclosure, and I simply adopt those. I don't propose, Mr. Chairman, unless it would be of assistance, to go through the risk of harm and danger under the public interest balancing exercise. We've dealt with that starting at page 223 of the HMG submissions, but there are certainly overlapping considerations as between the Article 2 risks and the environment in Northern Ireland and the risk of harm and danger that might be considered under the balancing test, if necessary, in a slightly different context. HMG acknowledges that some of the core participants have expressly recognised the different and special operational context within which intelligence personnel operate. And while I don't propose to take you through the witness statement and open damage assessment in any detail, Mr. Chairman, you will see the reference in the witness statement at paragraph 8 to the fact that the witness indicates we live our lives carefully, conscious of the need to protect our identities. By definition, these are people who protect their identities on a daily basis. It's not possible to substantively address in open all of the points which are raised in submissions made by other core participants. It will be possible to deal in further detail with some of those points in closed, Mr. Chairman, but unless there's any point on which I can specifically assist you, I think much of the ground has been covered by my learned friends.
Yes, thank you very much, Ms. Fee. Well, Mr. Greenie.
That would seem a convenient moment to stop for the day and to start again, please, sir, at 10:30 tomorrow morning.